Yes.
Hardship spoken to the previous matter is that there are two mistakes. Like there are mentioned. One is regarding that the girl child can stay beyond the stipulated time, and second one being that I will pick up and drop the child. That has not come in the order.
Lordship, serial number 30.
No, that page wise they'll call anything out of the list.
Yeah, writ petition 26166, Your Lordship. There is a mistake. By making the order, the previous award must be 15,000, and from the date of the order, it must be 20,000. While in the order, it has not come so, Your Lordship.
Yes.
It may
Next.
be posted tomorrow. For being.
Yes.
Page adjustment,
The
page 1, serial number 1 and 2, page 2.
Serial number 2, my lad. I have taken entire the proceedings of the order copy, my lad. Will produce the stage of the suit. It is a defendant evidence. My application, my lad, for filing the return statement that was dismissed by the.
Hear it.
Yes, please.
Will hear it. Yes.
Page
All
number
these 2019, 17 matters, please don't make a mention, will not grant at any cost. After 2016, call from this 13.
Page
Yes.
Serial number 4, I am filing
memo.
Huh?
for withdrawal. I am filing memo for
Which one?
serial number 4.
Serial number?
4.
Yes. What is that? A memo is filed stating that the memo for withdrawal is filed stating that the main MC, that is MC number 406 of 2016 on the file of the family court, Mangalore itself was disposed of by mutual consent and decree has been passed. And this petition has become infructuous, dismissed as withdrawn. Yes.
Page number 5, serial number 13, 28, 20.
I'm for responding.
Is it so?
Point number 3.
Pose this matter on August 21st. It is submitted that the settlement talks are going on. August 21st. Yes. Interim order earlier granted is extended.
Serial number 26, my lords, not yet called.
Page 6.
Yes.
My lords, kindly give us a short adjournment, my lord. Senior has undergone minor surgery, so.
Serial number 21 to 26.
At the request of learned counsel, the petitioner poses
26.
matter on August 13th. Yes.
Page
Serial number 24, Your Lordship.
Yes.
For the respondent, Your Lordship, I seek 2 weeks' time to file their objections, Your Lordship.
24.
Serial number
at
24.
request, Post on 20th of August.
Grateful.
Yes.
Page number 7, serial number 27 to 30.
No, 1 minute. This 24, who
Lost.
has moved this memo?
The petitioner has moved the memo, Your
But
Lordship.
then how can you make a mention for adjournment? Have you informed them?
Your Lordship, we tried calling them at multiple occasions in the. We tried calling them multiple times. We were not able to reach them, Your Lordship, but we'll inform them.
No. Please don't make a mention when somebody else has moved the memo. You have to wait till the matter reaches. No adjournment.
Please, Your
Yes.
Lordship, please.
My lord, serial number
Lord.
27, my lord.
20?
27, my lord.
30, page
The
7.
matter may be adjourned and taken up in the next week, my lord.
Who has moved the memo?
I have moved the memo, my
But
lord.
then why are you asking for adjournment?
Lord, I am actually the proxy counsel. The counsel on record is indispensable due to some.
27, post on August 13th.
Lordship, serial number 30.
To the petitioner.
Page number
Grateful, my lord.
Lordship, serial number 30. I appear for petitioner in one of the connected matter. I need to file objection for the first serial. number.
What are these objections in a writ petition? I'm not able to understand.
There are certain
Everybody has objections. No, whatever is the order of the court, that will be decided here. What is the jurisdiction of this court to take everything and consider now? So let's stop this practice of objections.
I need some time to,
And then you tell
I've
that.
informed the other side.
I appear for the petitioner in this matter.
30,
my lord.
30 minutes.
30, post along with so and so on 9th of August.
Much obliged.
Obliged.
page number 8, serial number 31 to 36.
Serial number 35, being settled. But we had earlier mentioned to your lordship that dogs are going to be, both the husband and wife want to be United States of America to visit their son. Lords could have it after a week. I've informed the other side in the morning, but she has no.
It is submitted that the compromise talks are going on. Post this matter on 13th of August.
My lord, 36, my lord, serial number.
For dismissal.
My lord, serial number 36, my lord,
Yes,
may be taken up in a week's time, my lord.
why?
My lord, to produce some memo, my lord, they last time they made some submission, my lord.
What memo you want to produce? I
My lord,
remember this case. I remember this case, it can't be adjourned. Yes, next.
Page number 9, serial number
Yes, my lord,
31 to
much obliged.
41. Page number 10, 42 to 45.
Serial number 45, my lord. I filed memo for withdrawal in matter. The matter will be withdrawn.
A memo is filed, why it has MC is disposed of?
No, my lord.
Oh.
Petitioner wants to continue the MC. This is-
Oh. The memo is filed seeking to withdraw the writ petition. Accordingly, memo is taken on record. Dismissed as withdrawn. Yes.
Please.
Page number 11, serial number 46 to 48.
Yes, call the list.
Page 1, serial for dismissal, serial number 1, HN Basuraj.
Kindly pass it over, my lord. My senior counsel will come and direct.
And for the petitioner.
First matter,
Yes,
how
please.
can it be passed over?
No, it is held up in quota number 8, my lord.
Subsequently, last hearing date.
Kindly pass it.
What we will do is immediately after that case, ask him to come here.
Please,
The moment he comes, it will be called.
Please.
Yes, for next matter.
Serial number 2, Kaka Reddy for petitioner.
Yes.
But in this case, my lord, the petitioner who is the fifth defendant in this,
First of all, what happened to the notices? Are they served?
my lord, notice was not served, my lord. The defendants, what happened? My lord, kindly see the one, the Wakalat has not filed in this original suit.
Dismiss for non-prosecution. Let's see, when is the order?
In,
I think IA is coming up.
yes,
When was it dismissed? Where is that order?
(23/8/2019).
It's a writ petition of 2018. Dismissed for default on 23rd August
2019.
2019.
Even though,
What has happened on that day?
my lord, non-compliance
3
of
weeks time
office-
is granted finally for compliance of office petitions, failing which the petition stands dismissed on its own. Where is the affidavit now filed with a delay of 1,244 days? What are the reasons for that?
1/24.
Huh?
1/24.
Let's see. What did you say?
Para number 4.
How to take this affidavit into consideration? What are the reasons?
My lord, this is the partition suit, my lord.
Whatever
Doctor
it
has
is.
filed, my lord, the rights of the parties is involved. Earlier, what happened, my lord, she has not appeared before the trial court. My lord, she came to know that the suit is pending in respect of the partition suit. My lord, kindly see the one wakalat.
No, no, we're not going to that.
My lord,
No, you have questioned an order passed by the court below, where there also your appearance was not there. Now you have come before this court, you will not comply with the office objections. An order will be passed in 2019.
my lord,
With a delay of 4 years, you will come up with this IA.
before my lord, dismissal of non-prosecution, my lord, the office objections complaint. That was not brought in. 1 week time has been granted for complaints, my lord. Within 1 week,
No, what was happening when an order is, why there was no no, if such an order is passed and you know that the office objections are complied with, you would have come up with an application immediately. But you have come up after 4 years.
that the advocate, it is a mistake of the advocate. Therefore, my lord, earlier, my lord, in the wakalat, kindly the page number 64, my lord.
It
What happened
clearly
in the
shows, it clearly shows
proceedings, my lord,
that the petitioner is not pursuing the matter. Why these kind of, no, what was the order of the trial court?
my lord, trial court, my lord, the petitioner appeared before the court, filed the written statement and counterclaim in the partition suit. That permission application was dismissed by reason that wakalat already filed. Kindly see the wakalat, my lord, the page number 64.
No, we are not going to the trial court, we are still here.
My lord, that wakalat, she has not signed the wakalat. His brother has manipulated that the wakalat stated to be filed on behalf of the defendant number 5. Kindly see, my lord, the page number 64. The prima
No,
facie
in
document,
every
my lord.
case, no, in every case with this kind of delay,
In
just,
this, my lord, only the merits of the matter, my lord, this is the parties are the partition suit. Their rights are involved in this, the.
if their
partition.
rights are involved, they should pursue the matter also.
Kindly see the wakalat, my lord.
Not the
She has
wakalat.
not filed
No, why,
wakalat,
what
my
has
lord.
happened before this court?
In this, my lord, trial court record the reason, backside has put the signature. This is
No, in
only
the
the reason.
2018, no, in the 2018 suit, you just keep quiet. What is the
But
suit? Which
till
year is
date-
the suit?
Till date, my lord, this is then, the matter was, the set down for the defendant evidence. That is the entire order sheet I have taken, my lord, earlier.
That's not the ground.
Submission, my
That is
lord.
not the ground.
Kindly see the.
No, now this will be allowed and you will go to the court and then another 10 years for these kind of petitions.
No, my lord, this is the impleading applicants appeared and.
OS number 1998, OS of 1998,
565 or 97 so.
97 suit.
Now the stage for the cross of defendant number 1. That is the entire order sheet I have taken, my lord. No
So
changes.
first of all, how much cost for this? How much cost for this delay?
And maybe even 10,000 maybe impose the cost.
No issue, this is not the way. I outrightly want to dismiss this IA of yours.
The daughter suit, my lord, the.
A daughter or son doesn't matter.
Don't
A litigant
file
is
this-
supposed to be vigilant, pursuing the litigation. Now in a 2018 writ petition, now the notice has to go. When will that notice go? When will this matter be heard?
We will,
When will the suit will?
we will serve the copy to on record advocates in the trial.
What were you doing without pursuing this when it is dismissed?
Some that cost may be imposed and allow the.
I'll impose 50,000. If it is agreeable to your client, please tell the court. Otherwise, I'll not pass any order. These kind of litigation can't be. Ask your client if he's ready for 50,000, we'll impose and then pass over. Next matter.
Please. Mr. Anand Krishnamurthy for petitioner. M. Suresh Reddy.
The respondent. This, sir.
Yes.
Suit for ejectment. I filed the claim.
What is the suit for?
Suit for ejectment.
Ejectment. You are the?
And the plaintiff, Arun Kumar, he is defendant number 5. He died. A memo is filed by the advocate on record, stating that the last statement kindly served to say
Notices is served to all the respondents.
all the respondents are before court.
Yes, please argue the main matter. Where is the impugned order?
Impugned order.
51,
last
page
May-
number 51.
So that last may turn to page 38 and
Yes.
38 is in Kannada. It is a letter addressed by the brother of the deceased to the advocate stating that the keys are delivered to Srimati Lalita. Page 39 is a memo filed by the advocate. Page 39, the last may turn to page 39. Defendant 5 as follows. It is informed by the brother of the fifth defendant. that Defendant 5 was expired and possession of the scheduled premises has been handed over to their landlord, Srimati Lalita. Page 39, my lord. 39.
I've seen that. Where is the order?
Order
Let us see the order.
51, 51. Page number
51.
51.
Last may turn to reasons at page 52. In the course of the argument, learned counsel representing plaintiff has argued that plaintiff had purchased the suitable property from the previous owner, Sri B. S. Keshavamurthy, under the register sale dated 18/7/85. And at that time, defendant was the tenant and Sri B. S. Keshavamurthy, and he was paying rent.
So court has dismissed that application to implead
Yes,
that,
on the non-merits, not on the ground whether she is the legal representative or not. You have to pay fee.
no, the court felt that in the suit for ejectment, she is not a necessary party.
No.
Uh.
I must file a suit for declaration of title on merits. You have to can be seen.
Where is the, you said it is just a suit for ejectment.
Statement. You have to turn to page 53. Page 53 bottom. On thorough scrutiny of pleadings and connected records, it is ascertained that plaintiff has not produced any documents to show that the fifth defendant was a tenant, sub-tenant, and him in respect to the suit property. The fifth tenant has paid rent to the plaintiff at any point of time. It is relevant to note that plaintiff has not produced copy of the rent lease agreement or copy of the rent received receipt or any other document which enables the court to believe that there was a landlord and tenant relationship between plaintiff and fifth defendant at any point of time. In the absence of any piece of document supporting the contention of the plaintiff, it is very difficult to accept the contention of the plaintiff that once the fifth defendant was a tenant, sub-tenant, and him in respect to suit property, and he had collected rents from him. In the absence of true relationship between plaintiff and fifth defendant as landlord and tenant, so it is not fair on the part of the court to hold that Lalita, wife of B. L. Keshavamurthy, from whom plaintiff has alleged to have purchased the suit property as a legal representative. Instead of passing orders and application, it has gone on merit, whether I have rent receipts or not. Order 22 Rule 5, like only limited to whether X is the legal representative or not on merit. They are not considered the application on merit. It must be remand, a matter which case for remand. You last may turn to order 2 Rule 11. Read with order 22 Rule 5. An inquiry must be held. Your last may see covered by a judgment.
No, first, one clarity on facts. Court below says you have not sought for declaration, you say you have sought for declaration.
No, I'm not saying declaration. Earlier suits are there. Suits filed by the landlord on the has been dismissed or default. Appeal dismissed, disciplinary dismissed, CRP file dismissed, review petition dismissed. Other, I have not produced unless I step into the witness box and give evidence. The learned judge cannot pass say that I have not produced any document. I have got all the documents. And there is a direction by this honorable court directing the fifth defendant to deposit rent in court. 22 2 Rule 11. Your last is the candidate term to 2 Rule 11.
Yes.
The objection is that she is not a blood relative. That is 2 Rule 11.
Definition.
Of legal
Order 2 Rule 11.
Yes.
Definition.
Definition. Legal representative means
Yes.
a person who in law represents the estate of the deceased person and includes, you last it, and includes any person who intermeddles with the estate of the deceased. Last it, got it?
Yes.
211.
Understood.
Any person who.
Section. Yes.
211
Yes, yes.
and 22 Rule 5.
Yes.
22 Rule 5.
Yes.
Last it, got it?
Yes.
Determination of question as a legal representative. Where a question arises as to whether the person or is not the legal representative of a deceased plaintiff or of a deceased defendant, such question shall be determined by the court. Instead of determining the question whether X is a legal representative or not, it has gone on merits
Yes,
covered by judgment of the apex
yes,
court.
what is,
Remand, it requires a remand.
Huh.
Covered by a judgment of the apex. May I just pass on the judgment?
Yes, please
of
pass.
Justice Ramana and.
I represent respondents.
2018.
He has
Respondent to
please pass on the judgment. Yes.
what I could make submission before this court is, what is contemplated in Article Rule 5, the court has already given a finding to that effect, to say that since there is prima facie no document evidencing the fact that whether she is an LR or not, it cannot,
Yourself, that memo is filed.
that memo is filed by respondent number 5.
Who is respondent number 5?
Respondent number 5 is on Arun Kumar.
Oh.
And this lady is not related to it. What is contended in that memo is to say that I have delivered possession.
Oh.
What is contended in that memo is,
What is your case?
my case is there is no relationship of landlord and tenant.
No, what is the relationship between you and Arun Kumar?
No, I don't have any relationship with Arun Kumar. I don't represent the person who they wanted to implead. I am a defendant in that case. In fact, they don't even implead that party before this court. Even if no, my lord were to allow that application, they should be heard.
I made an application for impleading.
So that impleading application is filed on the premise
No,
that
that
he is
is
an
it.
LR.
Probably the cause list he wants to, the cause title he wants to amend.
He should have done, that is what the other day I told. They will have to simply say that cause title needs to be amended to implead that party as a party. But their affidavit says, since she is an LR of R5, they had made that application. In fact, this is what I wanted to bring before my lord on the other day. All that they were supposed to do is tell fairly before this court that we have not made her as a party, permit us to make her as a party, not as an LR as R5. That will be decided by this court.
Remanded, he will be heard in the matter.
No. How can an order be passed against a party who is not before this court?
Necessary application tomorrow itself to bring her on.
Yes, what you have to do is you have to amend the cause title, that's it. It should have been done long back, 2016 writ petition.
Till that, that is not.
Without a party being here and the matter is pending. Post this matter tomorrow. If the necessary application is not filed, the writ petition shall stand dismissed without further reference to the court. Yes.
For disposed, seal number 5. Ita Devi MP for petitioner, Yamalata Mahishi.
I appear for the respondent.
Yes.
My lord, in this matter, my lord, the suit filed by the husband has been dismissed by the family court on the ground that the marriage between the husband and wife are not subsisting as the petition was filed. The divorce had taken place, my lord, between the husband and wife on 17/2/2006. 17/2/2006. The property was purchased 15/9/2004 during the subsistence of the marriage. The dispute arose, which was not regarding this issue of the division of property, or rather, it was his property which he had purchased. It was registered in her name. Now, dispute arose regarding this, and he issued notice in 2009 and then filed the suit, my lord. After 8 years of the petition, hearing of the hearing the matter, trial was conducted, issues were framed 2 times, 3 times issues were framed. Thereafter, my lord, at the final argument, the court has disposed of our main petition on the ground that this court does not have territorial jurisdiction. It should go before the proper court and return the return the suit. The papers to be returned. Therefore, my lord, I had raised this question, my lord, the marriage subsistence or not.
No. Please come to the order. Please come to the judgment.
My lord. Annexure F at page 61, my lord, that is the impugned order.
It's a final order.
It's a final order.
How can a writ petition lie?
My lord, please, your lordship may kindly see here, my lord, that the order is to page 100.
So
your
whatever
lordship.
it is
It's
a
at page 100, your lordship may see, my lord.
Huh?
It is returned as not maintainable. So the suit is not.
How can
disposed
that
of.
be returned at the time of?
That is why I am before your lordships, my lord. That's why this interim order was granted. At page number 100, my lord, 31 page, paragraph 31, my lord.
2009 suit.
Yes, my lord,
When was it returned?
17.
But ultimately, the fact remains is that the suit is not maintainable before the family court.
That's why, my lord, I have certain citations which I would like to place on record, my lord, which I had cited before the family court also. Lordship, kindly grant me 2 days time, Wednesday I'll argue the matter on merits, my lord. The grounds they say is that subsistence of a marriage was relevant to the family court.
Yes.
That is not the Supreme Court judgments are there to that effect, my lord. I'll place it.
No, the whole purpose of suits being tried between the parties before a family court is when there is a dispute between them. And so that if all the disputes arising out of the between the parties has to be decided. For example, somewhere in 2006, everything has attained finality as well as a family court's jurisdiction is concerned. And whatever the differences, disputes throughout the life, how can it be decided? That's what the Supreme Court said.
Judgment is there, my lord. It pertains even to the matter.
Heard the learned counsel for the petitioner, pose this matter as a part heard on Wednesday, on the top of the list. Yes.
May I make a submission?
Huh.
Serial number 42 is there.
Hmm.
Your lordship wanted to hear it on merit. May I come at 2:30? 42.
That's not the way to make a mention now that you appear in
Only
one
today-
matter
Today itself at 2:30.
and ask for a matter which is at 42. Please come, but you shouldn't make a mention like that.
Very good.
Pass over. Yes.
Then number 6, Usha MB. Usha MB for petitioner.
You're for
Yes.
respondent.
You're for the respondent.
Respondent.
No representation on behalf of the petitioner. Counsel for the respondent is present. Post for dismissal tomorrow.
Then number 7. Nehru P for
Appearing
petitioner.
for the petitioner, my lord.
Yes.
My lordship has ordered to issue the notice to the opposite counsels. We have issued. And then we filed the memo also, my lord.
Where are the councils? Every time this is the same thing they're doing.
Yeah, Sheshwat.
What is that number? MFA?
MFA is 2040, my lord.
Huh?
2040
2040?
of 2024.
2024.
Yes.
Please come. This writ petition is of the year 2017. And the respondent herein had already filed MFA 2040 of 2024.
Yes, ma'am.
And conveniently, in spite of the name, in spite the cause list shows their name, they're not appearing before the court from the last 2 occasions. After obtaining the necessary instructions from the Honorable Chief Justice, either this writ petition be clubbed with the MFA number 2040 of 2024 or the MFA be clubbed with, that is a division bench one.
Yes.
This writ
Perfect.
petition also may be tagged to that MFA number 2040 of 2024. Yes.
Yes, ma'am. Much obliged.
Now, what is this order?
No, this order is actually the writ petition, I mean, in divorce case, they have given maintenance only for the child, my lord.
No, when that attains finality, what is the significance of this now?
No, even that they are not paying regularly.
No, it is an interim application that's ordered. Now the final order is passed. No, this order is deemed to have been merged with the final order. So what would be decided by this court?
This
If
we-
you have anything, you have to agitate before whatever you have to seek in the MFA.
My lord, we have filed the execution petition there. That is also they are not complying with.
It is true,
All those
Mr.
things are
Counsel.
happening, my
No,
lord.
the thing is,
Yes.
you can't pursue this. After, it's an interlocutory
Yeah, that's
application.
right. I do agree.
Please come. Agreed with order, passed in, so and so. Agreed with the order,
My
passed
lord, they
in.
have not considered the wife.
Huh?
They have not considered the wife at all.
That's what
Because-
the court will,
Ah,
that you can ask in the court. Now this can't be decided.
Okay.
Agreed with the orders passed in I number 3 in MC number 2167 of 2015.
Yes.
The wife is before this court. It is submitted that during the pendency of this writ petition, the MC itself is disposed of against that. MFA 2040 of 2024 is filed before this court. As this is an interlocutory application and already final orders are passed, nothing survives to be decided in this writ petition. the petitioner is at liberty to agitate all the issues before the, in the MFA. Yes.
Cell number 8,
Much obliged.
appeal and not agree for petitioner.
Accordingly disposed of.
For the petitioner.
Number
Yes.
8,
Yes.
Please. It's a defendant's petition, Lords.
What is the suit for?
A suit for declaration and consequential relief of injunction not to interfere. Lord, admittedly, this property belongs to my
You
father.
said you are the defendant.
I'm the defendant.
Hmm.
I'm the defendant.
What is IA?
IA, my lord, he has filed an IA seeking an injunction against me not to alienate the property. A humble submission, my lord, your lordship may kindly see that
What did the trial court do?
trial court dismisses his application.
Then what did the appellate court do?
Then that application has been allowed.
Now let's see the trial court order first.
Please, my lord. Trial court order, my lord, your lordship will find. Trial court order, my lord, your lordship.
At 24.
Pardon me?
At page number 24.
Yes, ma'am. Page number. Reasons, your lordship, my lord, will find on page
No,
number.
let me just see the facts also.
Yes. May I read it, ma'am? Paragraph number 3, no, the plaintiff, the paragraph number 2, the plaintiff is the absolute owner in possession and enjoyment of the property. Earlier, Jodi number 224 and new number 150/5, measuring 24 guntas out of 31 guntas, situated at Medihalli village, Vemgal, Hobli, Ola, Palka, bonded on so and so and so. The plaintiff further submits that the previously Medal village as a Jodi Gram, the scheduled property has earlier the Jodi survey number 224. After the survey settlement, the suit scheduled property has got a new number as 150/15. Originally, this property belonged to one Mir Jafar, son of Miraj Shabi, Mir Sharif, son of so and so, and Mir Muhammad, son of Hussein Sabi. I am the son of Mir Jafar. Defendant is during the lifetime of Mir Jafar and Mir Yusuf and Mir Muhammad, they sold the scheduled property in favor of plaintiff for a valuable consideration through a registered shaded by number so and so, dated 28/3/1964. After the purchase of the suit scheduled property, the plaintiff was in peaceful possession and enjoyment over the same without anybody's interference. After survey settlement, in respect of the scheduled property, the new survey number so and so has been given to the suit scheduled property. Due to the illiteracy and innocence of the plaintiff, the revenue officials have not mutated the revenue records in favor of the plaintiff. That the defendant is not having any right, title and possession over the suit scheduled property. The RTC stands in the name of the vendor of the plaintiff, that is Mir Jafar, till 2012-2013. By taking the undue advantage of the same, the defendant, by colluding with revenue official, created the revenue documents in his name illegally without the knowledge of the plaintiff. When the plaintiff came to know about illegal entries, he preferred an appeal before the Assistant Commissioner Kolar in RA number so and so for the disposal of the least illegal entries. Appeal is pending for adjudication. Further, by virtue of the said mutation, defendant is illegally trying to interfere with the peaceful possession of the plaintiff and trying to dispossess the plaintiff from the suit scheduled property, and also defendant is canvassing for alienating in respect of the suit scheduled property of the third person. When the plaintiff questioned the illegal act of the defendant went up to the extent of denying the plaintiff's title over the scheduled property, hence the suit. On the other hand, the memo, the defendant has resisted the claim of the plaintiff by filing a written statement and also a memo to accept the written statement of as objection to IA number 1. The defendant has denied all the averments made by the plaintiff in the plaint. He further submitted that the land bearing number 150/5, measuring to an extent of 31 guntas, is situated in Medihala village, Vemgal, Hobli, Kolar, Talsa. originally belongs to the defendant's father, Mir Jafar. It is ancestral property. All the revenue documents stood in the name of Mir Jafar. After the death of Mir Jafar, Khata has been changed to his wife's name, that is Fatima Bi, as per Pavati Vasa in MR number.
Where is the appellate court's order?
Pardon me?
Appellate court's order.
Yes, ma'am. Page number, my lord, 32. Yes, ma'am. The appellant sellers of the deceased plaintiff have preferred this appeal under order 43 rule 1 so and so, being agreed by the I number 1 under order 39 rule 1 and 2 CPC dated 28/9/2016 in OS number 591/2014 on the file of first additional Kolar, wherein the lower court has dismissed the IA. The parties will refer to as per their ranking in the trial court. The plaintiff had paid for temporary injunction against the defendant, restraining from alienating the suit property pending dispose of the suit. The case of the plaintiff in brief is that he is the owner in possession of the suit property, which was Jodi number so and so, and new number so and so, measuring 24 guntas out of 31 guntas, situated at Medahalli village, Vemgal, Hobli, Kolar, Talaka, and previously Medahalli village was Jodi village, and after survey settlement, the Jodi number so and so is renumbered as survey number 150/5. Originally, the said property belongs to Mir Jafar, Mir Yusuf, and Mir Muhammad, and during their lifetime, they have sold the said property in favor of the plaintiff under registered CAD dated 28/3/1964, and the plaintiff was in possession and enjoyment of the same without any interference from anyone. After the survey settlement, new survey number 150/5 has been given to the suit property. Due to illiteracy and innocence, revenue officials have not mutated the revenue records in favor of the plaintiff. The defendant is not having any right, title, or possession over the suit property. The RTC stood in the name of the vendor of the plaintiff till 2012-2013. By taking undue advantage of the same, the defendant created revenue documents by colluding with the revenue officials without the knowledge of the plaintiff. The plaintiff had preferred an appeal before the Assistant Commissioner, Kolar so and so, and the said appeal is pending adjudication. The defendant is trying to interfere with possession of the suit property and trying to dispose of the plaintiff and trying to alienate the suit property in favor of a third person, and hence the suit, so and so. The case of the defendant that has then, Lakshmi, kindly permit me to read from paragraph number 5, my lord. The trial court has failed to properly analyze, weigh, and appreciate the documentary evidence placed on report by plaintiff, and the order of the trial court has resulted in great miscarriage of justice. The findings of the trial court are erroneous. The trial court has relied upon the orders of Assistant Commissioner without applying its own mind. Hence, the same is erroneous. The trial court had failed to look into the document produced by the appellant, and hence the order deserves to be set aside. Reasons. These points are taken up together for discussion in order to avoid repetition for the purpose of brevity. When the appellant court interfere with the order granting of temporary injunction is discussed in the decision reported in ILR 19 so and so, and it has been extracted. Then, in view of the matter, only if the discretion exercised by the is totally against the pleading and documents placed on record, then only the appellant court can interfere with the exercise of such discretion by the trial court. If the reasons stated by the trial court are acceptable, view under law, then the discretion exercised cannot be interfered in the appeal. With this clear understanding, now let us meet prima facie the pleadings and documents placed on record. It is therefore relevant to note that the trial court has relied upon the observations of the Assistant Commissioner, whereby while rejecting the prayer for mutation in appeal preferred by the so and so is observed by the learned assistant, and then Kannada, this is there. Then how far as the above observation could be relied upon by the respondent is the matter to be prima facie considered at this juncture.
in the notes of arguments filed by the respondent on 5/12/2017, they highlighted that in the registered sale deed dated so and so, relied upon by the plaintiff, it is mentioned as settlement, that settlement has not taken place. But the detailed survey Tippani book extract mentioned that the detailed survey was done on 12/6/1962. And on that basis, it is argued that if at all the registered sale deed was executed, then what prevented from mentioning the new survey number, and therefore execution of the sale deed is improper.
Yes, I've seen. Yes.
Yes, Lordship, may kindly see, only two things I would like to, on two grounds, the trial court has rejected the IA number 1, on the ground that the defendant, the plaintiff did not produce any documents to show that the new survey number is 105/5, 150/5. And in my humble submission, my lord, the trial court was justified regarding the same. And secondly, your lordship may kindly see this, though the sale deed had taken place, my lord, way back in the year 1964, no steps were taken. And whether the sale deed was acted upon or not is not known. And your lordship may kindly see that all the revenue records still stands in my name.
Yes.
And lastly, my lord, a short submission, my lord. The interim prayer granted to the plaintiff is not in consonance with the final, the prayer made in the plaintiff has only prayed for. One is to declaration, and that I am to restrain interference. There is nothing in the prayer to restrain me from alienating the property. These are my submissions and declaration.
We'll ask.
This defendant, his father in 1964, he sold the property to the friend. Now the resurvey has been given new number. He incorporated his father's name and mother's name, then started to interfere.
When was the mutation in his name? Which year?
2013, my lord.
2013.
Yes.
Prior to that, it stands in the name of the parents.
Father.
Jaffer.
No mutation is made in there.
Not name.
Oh.
Mutation in the name of the defendant.
Defendant, yes.
Defendant's father name was.
First in my mother's name, thereafter in mine.
Yes.
So the property was sold by the family members. Now he created another number and started to interfere. My first say. This the appellate court, lower appellate court has correctly analyzed the documents. There is a standing of ISA survey number, old survey 155/5, and parallel with the new survey number. These are the equal. These are the explanation given by the appellate courts now. So same survey number and boundary also explained, same boundaries there. So the order is given is not to alienate the property. He has recorded the revenue record, try to alienate the property. But that is in order to maintain status quo of the order. The honorable court, the lower appellate court is passed not to alienate the property. There is no harmless order. So the proper order has been passed from lower appellate courts. The petition has to be dismissed.
Yes, please come. The present appeal is, this petition is filed by the defendant, agreed with the order passed in MA number 01 of 2017 dated 7th December 2017 by so and so. The facts of the case are, the petitioner herein is a defendant and the respondent herein, who is a plaintiff, had filed a suit for declaration and for injunction. It is the case of the plaintiff that he had purchased the property in the year 1964 by way of a registered sale deed. An extent of 24 guntas of land.
24.
An extent of 24 guntas. The revenue and in the revenue records, the vendor of the plaintiff name remains to be in the revenue records. Then in the year 2012, the defendant, who is the son of the vendor of the plaintiff, had mutated his name in the revenue records and started interfering with the position of the plaintiff. As such, he has come up with the present suit seeking declaration and injunction. In that, he has filed an IA not to alienate the suit scheduled properties. The trial court had dismissed the said IA. The trial court had dismissed the said IA on the ground that there is no document to show, no material is placed before the court to show that he has been in possession of the property right from the date he has purchased it. And all the revenue records are in the name of the defendant. There is a division of property, subdivision of the property, and whether the property which he has purchased and the property subsequently subdivided is one and the same. Even with regard to that also, no documents are placed before the court. That's what I'm referring to, before the court. As such, the court has come to the conclusion that there is no prima facie case or balance of convenience in favor of the defendant, in favor of the plaintiff, and dismiss the IA. Aggrieved thereby, the plaintiff had carried the same in MA number 01 of 2017 on the file of the additional senior civil judge Kolar. And the learned judge, by order dated 7th December 2017, had allowed the IA. While allowing the IA, learned judge has observed that the reference to the previous survey number 224 and the reference at serial number 77 and subsequently serial number 150 is found in the detailed survey Tiffany book, and the said survey is pertaining to survey number 150. This clearly correlates the previous survey number 224 to the present survey number 150, and the said aspect is not noted by the trial court in its proper perspective. The registered document of an undisputed point of time is relied upon by the plaintiff, cannot be undermined. It was barely 6 months from the date of resurvey measurement that the registered sale deed is executed. Hence, the private parties coming to know the new survey numbers within such a short time is improbable. This seems to be the reason why the old survey number is mentioned in the sale deed, and also the survey settlement is yet to be done. And the court had also observed that mere denial of a registered document by the legal heir of the executant cannot be a ground to arrive at a conclusion that a prima facie case is not made out. The prima facie case is not prima facie success, but an opinion that there exists a tribal issue which requires recording of evidence and decision on merits. The temporary injunction claimed is not to alienate the suit property pending disposal of the suit. It is not in the temporary injunction claimed is not to alienate the suit property. It is not in respect of interference. It is therefore relevant, and it is harmless relief totally intending to preserve the rights of the parties intact pending disposal of the suit. And the court felt that the balance of convenience lies in favor of the plaintiff. And if such a relief is not granted, the very right claimed by the plaintiff, getting geoparadise, cannot be ruled out. And accordingly, the appellate court had felt that the conclusion arrived at by the trial court is improper, incorrect. And accordingly allowed the MA. Learned counsel appearing for the defendant submits that the trial court had rightly appreciated the evidence placed before the court and rightly come to the conclusion that the relief that is sought by the petitioner sought by the plaintiff cannot be granted as he has failed to prove the prima facie case, balance of convenience and irreparable loss. It is submitted that all the revenue records are in the name of the defendant, which shows that the plaintiff was never in possession of the property. It is further submitted that what was your other submission?
That is, my lord, that the
The
interim
relief
order
that is
is
sought,
here.
the relief that is sought in the main petition is unconnected with what he has sought in the IA. That is it? That's it?
That's all.
And and he submits that the court below ought to have, the appellate court ought to have dismissed the MA next part. Land counsel appearing for the plaintiff submits that the appellate court had rightly considered and rightly observed that such an order of granting not to alienate it's a harmless relief to the parties. He submits that the sale deed, which is of the year 1964, and the appellate court had rightly considered the same, and also the detailed survey Tiffany book, and has come to a just conclusion. He submits that by this interim order, the defendant, no prejudice would be caused to the defendant. And if such a relief is not granted, it would cause a lot of prejudice to the plaintiff, and also it would give rise to multiplicity of proceedings. The proceedings, it is submitted that the writ petition is liable to be dismissed. Next. Having heard the learned counsels on either side peruse the material on record, the plaintiff had filed the suit for declaration and injunction, and he is seeking a title to the property based on a registered sale deed, which is of the year 1964, executed by the father or mother?
Father and his brothers.
Father and brothers of the defendant.
Father and his brothers.
Father and father and uncles of the defendant. It is the case of the plaintiff that after the purchase of the property, he has not mutated his name in the revenue records. And in the year 2012, the defendant, after the death of the parents, had mutated his name in the revenue records and started interfering with the properties. The trial court had dismissed the petition on the ground that he couldn't show that as on the date of the possession, as on the date of the filing of the petition, and from the date of the purchase, he was in possession of the property. And as the name of the defendant is there in the revenue records, on that basis, the court had not granted the interim, the IA, the relief sought in the IA, that is not to alienate the property. When an application is filed seeking an injunction restraining a party to do a particular act, it is for the party who is claiming such a relief to show a prima facie case, a balance of convenience, and the irreparable loss. Here, this is not a case where the defendant plaintiff had sought for an injunction restraining the respondents from interfering with this property. If that is the case, as rightly held by the trial court, the defendant, the plaintiff has to prove that he has been in possession of the property from the date of the purchase of the, purchasing the property in the year 1964. Now, that is not the relief that is sought. Now, what the relief that is sought is not to alienate the property. Prima facie, he could show before the court that, that he has purchased the property by way of a sale deed. And the defendant, who is a legal heir of the original vendor, denies the same, saying that such a document is not executed. And there was a subdivision, and all other issues are has to be tried by the court in the court while in the trial. But at this stage, he had made out a prima facie case, and if such a relief is not granted, that would it would definitely cause irreparable loss to the plaintiff, as the third party rights would be created. And his the relief that is sought in the petition would itself be frustrated. By giving such a relief, the no prejudice would be caused to the defendant. The appellate court had rightly appreciated the case in a proper perspective and granted injunction restraining the respondent from restraining the defendant from alienating the property. This court finds no reasons to interfere. Accordingly, the petition is dismissed.
And the matter is posted trial court for arguments. Plaintiffs are argued, defendant taking the time a lot. It is
When
posted
is the suit?
30th of this
No,
month.
no. Which year is the suit?
This is the year.
Which year is the suit?
17.
Starting you must have got.
7.
7,
14, my lord, 2014.
2014. Next, the trial court, the suitors of the year 2014, which is nearly 10 years old, the trial court shall dispose of the suit itself within a period of 6 months from the date of receipt
No,
of the
argument
document.
stays with you. Argument matter, defense side argument, they are taking.
It's coming up for arguments.
Argument, the defense side. My side is over.
3 months.
3 months.
Yes.
Cell number 9.
Yes.
G.K. Bhavana for petitioner, Nasim Raju for respondent.
Give 9.1. Where is that? Not memo, office note. So here it is there, no? No, it is. First time notice issued on IA 10 in respect of R1 A2F on 27/3. R1 filed, R1 to be served and unrepresented. R1 B and C addressee left. R1 A and D addressee expired. Petitioner to take steps in respect of A to E. The last one already on record as per so second time notice issued to not claimed. No, this is with regard to second one only.
Second one. Unclaimed.
No, because it is unclaimed in the first matter, how can it be? How can it be?
Yes, my lord, it's the same address.
No.
Very clearly.
Whatever
because
it is, there are 2 matters, you have to take 2 separate notices.
Yes.
Because in one thing they have said unclaimed, it can't be taken as unclaimed in the second one.
Second time, no, when the notice was issued in the second matter also, it has returned as unclaimed. First time it has returned as
It's only in respect of
R1B and C. Only with respect of R1B and C, my lord,
No,
the second time.
1 minute. R1B not claimed.
Yes.
R1C, no such person in this address. They put up the note now. For R1C, no such person in this address. Third time notice issued to R1B and C on 15/6/2024. R1B, postal tract does not disclose details.
My lord, as regards to R1B, because it has returned as unclaimed.
That will be done. For the remaining, you have to take steps.
R1C.
as per the office note, in respect of the notice sent on 1/4/2024, as far as R1 is concerned, as per the postal share shows as not claimed, the notice in respect of R1B is self-sufficient. The petition shall pay process in respect of R1C, R1B and C. B is, yes, R1C, yes, post after service of notice. Yes, next.
Serial number 10.
Give that letter.
For the petition.
A letter is addressed by the learned judge. 17th additions to the civil and session judge, requesting for extension of time to dispose of OS number 3094 of 2008. This court, by order dated 15/9/2023, I directed the court to dispose of the matter within a period of 6 months. Learned judge in the letter has explained why the same could not be disposed of and requested to grant further time for disposal of the suit. Hence, considering the same, another 3 months' time is granted for disposal of the suit. Yes.
And serial number 11.
Well, I seek for a week time.
You have to complete the process in this week itself.
Well,
not
what has happened is, as per the last instruction, they are in the outside court settlement for the matter, so.
If it is outside settlement, that doesn't mean that the writ petition shall be pending.
No, my lord, we try to contact them what has happened, if such.
No, you pay the process.
Yeah, I'll pay that, I'll pay.
Pay the process for that, that is altogether a different course. Pay the process within 2 days, or else it will stand dismissed. Writ petition of 2017, if the process is not paid within 2 days, the writ petition shall stand dismissed without further reference to the court. Yes.
Final hearing, serial number 12. Even Jane either.
Lordships for the petition. Respondent number 1, my lords. My lord, regarding the IA number 1, 2023, 1 and 2, 3, 4, I have no objection, my lord, in pleading application. My lord, in another application, it can take up the matter on the mains, my lord. For
No,
respondent,
we'll hear this coming up for final hearing. No applications now, interim applications.
because my lord, the notice, already notice is sent to the proposed respondent in pleading applicant, my lord.
They're all.
No,
The
what
legal,
is-
legal representative of the respondent number 1, my
They
lord.
are not impleted, they are not served, no, notice is not served.
Served, my lord.
Then, that is served.
Yes.
All other applications, we will not decide this coming up for final hearing. Only as far as that, this IA 1/23 for, so delay in filing LR application.
Those application, I have no objection, my lord.
Any LRs on record?
Yes.
No.
I'm the, LRs are not appeared.
No, notice is served.
Yes, yes.
No, we don't wait for them to come and appear.
Your lordships, notice have been served, your lordships, in return, we have not received the acknowledgement or the post cover, your lordships.
Well, acknowledgement also shows that the notice are served.
Look at it, Anita.
Only R2A, Dharmesh Ranga served, proposed,
Uh,
RB unserved, and RC is served, 2D also served.
On which date? sir?
2/8.
It was initiated on.
I don't know, but office note.
No, you will not receive the acknowledgement. Court has sent the notices.
Lordships, senior will appear, your lordships. A week's
Have
time. I
him
will.
to come. No,
Okay, lord.
not even a day more.
Pass or your lordships.
Yes,
Eight or
pass
12.
over.
Much of that, lordships.
Cell number 13. 13 adjourned. Cell number 14. Geeta Devi MP for petitioner. 14.
No representation of the petitioner. Pose this matter tomorrow for dismissal. Yes.
Cell number 15. J. Kumar K.
Appearing for petitioner. Petitioners are challenged the order in passed by the page number 17 is impugned order, my lord. For maintenance petition, my lord, the wife filed a maintenance petition against the husband.
How much was granted?
My lord, interim compensation granted, my lord, is 15,000 for a month.
Hmm.
My lord, my salary itself 13,500. I am working as a two-wheeler garage, as a laborer in the two-wheeler
How
garage.
much you will pay now?
Lord, only my grievance, my lord, is that 13,500. My mother and parents, and they are also my wife and two
So
children.
that's what I'm asking, how much you will pay?
7,000.
But when is the petition?
But the petition, my lord, is 2023.
When?
Yes, my lord. 30 August 23, 1 year.
8th.
Yes, 30th.
So it's almost
1 year.
months. Almost 12
1
months.
month.
Hmm.
12 months.
Please come. 1,44,000, huh?
Yes. And they need to disclose the trial court, my lord, as before passing order, only my submission, my lord, is that,
84,000. The present petition is filed, not present, the land counsel for the petition submits that when the petition's income itself is 13,500, court had granted an amount of rupees 15,000 as maintenance. In the, he had to maintain his old age parents and he cannot, is not in a position to pay the maintenance granted by the court. And all these facts were not appreciated by the court. Considering the same, there shall be stay of all further proceedings on the condition that he shall deposit 7,000 by 5th of every succeeding month. And for 12 months, the arrears at 7,000 would come to 84,000. The same shall be deposited within 4 weeks, either of it. If it is not done, the stay granted by this court stands vacated automatically. The petition shall take out notice on the counsel appearing before the court below and shall file for the respondent, and a memo to that effect shall be filed by 31st. Pose this matter on 23rd of August.
Cell number
And on such deposit, the respondent is at liberty in all the matters. You write that you should add it, whether I tell you or not. Yes. Yes, next.
Cell number 16. Gangadhar Payage for
Right.
petitioner.
Yes.
Ashoka T. Respondent.
Respondent.
Appear for
Yes.
the petitioner.
What is this order?
Two applications have been filed under Order 7 Rule 14, seeking permission of the court to produce electronic devices as evidence and stating that some expert has certified those as correct materials and he wanted to produce the documents. Now the point is this, petitioner is the wife. Their marriage was performed on 4/2/2021. 4/2/2021 is the marriage.
Yes.
She was thrown out of the house in the month of June 2021, that is on 18/6/2021. Within a short span of 4 months. She was brutally assaulted, thrown out of the stairs, and the parents were to pick her up, took her to their shelter. A complaint was filed to the jurisdictional police against the atrocity. Now, incidentally, I may bring to the notice of the court. The father of this respondent is and was an inspector in the police department. He managed to see that the complaint is not registered. By force, they took another complaint, registered as a complaint with a lower intensity. And they submitted the report to the court. That is the subject matter of another dispute. Now, to take revenge, he files a petition.
Please come to the impugned order so that it will be better. The court can
Yes.
appreciate what you're saying.
Yes.
Yes.
Now kindly see the application that has been filed.
No, before that we'll just see the order, then if
I
relevant.
will read the order.
Yes,
I will read the order.
yes.
The order is at
Page number 119.
page 116 it starts and the page 119. Order on IA number 4 and 5. Petitioner has filed application under order 7 rule 14 read with section 151 of the CPC seeking permission to produce documents for marking the same. In the
Who
accompanying.
is the petitioner in MC?
He is the husband.
Husband.
And I have also filed an application under section 9 of the Hindu Marriage Act.
Restitution.
Seeking for restitution of conjugal
Yes.
rights. Both are pending. In the accompanying affidavit is stated that the petitioner filed for divorce on the grounds of nullity due to non-consummation of marriage. Initially, Xerox copies of the documents were submitted with the petition. Subsequently, authenticated data, images, messages, audio and videos from respondents' phone number so-and-so were obtained from a forensic expert, Mr. Panindra, under section 5 of the Indian Evidence Act 1872. These documents are crucial for the case and are admissible under section 3 of the Indian Evidence Act. Additionally, the respondent had filed a petition against the petitioner and his family, resulting in crime
At
number.
what stage this application is filed?
Which application?
This application, at what stage it is filed?
They have been allowed.
At what stage it is filed?
Yes, at the stage of consideration of the application for payment of interim maintenance. At the stage of consideration of the application for interim maintenance, the learned judge of the trial court went on adjourning the matter day after day without taking that application, and even after arguing, the matter was reserved, and ultimately after long lapse of time, an order came to be passed ordering for payment of ₹5,000 per month. Be that as it may, I'm not on that point. Now, at this stage, application was filed seeking for production of these materials on the ground that they are electronic devices, and they have been produced before the start to be produced before the court. I filed objection stating that this is not permissible because the person who claims to be the expert, he is not an expert and he has no experience at all, and he is not a person as required under section 79 of the Information Technology Act. So therefore, that application was not maintainable. That was my objection filed. The learned judge has passed this impugned order. Kindly permit me to take page 120. Heard and peruse the material on record.
Yes,
Paragraph 6 I am read.
yes.
I have perused the entire material on record. On going through the materials on record, the petitioner has filed his petition under section 12 of the Hindu Marriage Act. The respondent has also filed the petition under section 9 of the Hindu Marriage Act and the same clubbed together. When the matter is posted for petitioner's evidence, it is at stage that the petitioner has filed instant application for production of documents. It is to be noted that as per order 7 rule 14(1), petitioner will have to produce documents at the time of presentation of petition, and as per order 14 rule 3 of the CPC, when a document sought to be produced in court by the petitioner, when the petition is presented and the documents mentioned in the list is not produced along with the petition, he cannot produce the same without the leave of the court he received in evidence on his behalf at the time of hearing of the
Yes, I
suit.
have seen.
Now, my submission before this honorable court is this. Under section 79A of the Information Technology Act.
Yes.
45.
Hmm?
It's to 45.
Before that, I will take the honorable court to section 45,
It's to 45.
45, 45A and 45 of the Evidence Act. 45 and 45A of the Evidence Act.
Yes,
Opinion of experts.
yes. Yes, please read.
Yes, please. When the court has to form an opinion upon a point of foreign law, or of science or art, or as to identity of handwriting or finger impressions, the opinion upon that point of persons specially skilled in such foreign law, science or art, or in questions as to identity of handwriting or finger impression or relevant facts. Section 45A. When in a proceeding, the court has to form an opinion on any matter relating to any information transmitted or stored in any computer resource or any other electronic or digital forum, the opinion of the examiner of electronic evidence referred to in section 79A of the Information Technology Act is a relevant fact.
Yes.
Now kindly go to section 79 capital A of the Information Technology Act.
Section?
79 capital A.
Yes.
Central government to notify examiners of electronic evidence. The central government may, for the purpose of providing expert opinion on electronic forum evidence, before any court or authority specify by notification in the official gazette, any department, body or agency of the central government or state government as an examiner of electronic evidence. It is only such authority or agency or officer or department can certify whether a particular electronic device is in fit and proper condition, whether the materials have to be produced before the court can be accepted. These are all the facts which are required to be taken. The learned judge does not look into this aspect of the matter and mechanically passes the order allowing the applications. So I am before this honorable court challenging the order passed on IA number 4 and 5.
Yes.
Your Lordship, my first submission is the father of the respondent number 1 is not an inspector. He was working as
That's not
assistant
relevant.
sub-inspector. He was retired prior to the
It's
marriage.
not at all relevant on the merits of it, please submit.
Your Lordship, now the learned trial court has allowed the application. He can take all the objections to the before the trial court. There is absolutely no necessity to come before this honorable court to say, questioning this order. Your Lordship, this honorable court has also issued direction to conclude the matter within 4 months. They are not cooperating, but there is a serious allegation of adultery and all. We have some electronic records. Now we have, in the petition also, we have stated all these things. In support of those documents, we have produced it. Therefore, this writ petition has to be dismissed, Your Lordship.
Please come.
And the case is at the initial stage. Evidence not yet commenced.
Please come.
It is not that I am coming in the way of the court, it is causing. In fact, the learned judge of the trial court went on adjourning as I submitted from day after days, and ultimately application for interim maintenance, the learned judge took nearly about 2 years and odd to pass an order. I am not responsible for the delay. My friend making an objection before the court stating that
Yes.
this has happened, it's not correct.
Agreed with the order passed in I number 4 and 5. In MC number in MC number 65 of 2021, dated once, what is the date of order?
Date of the order is page 119.
17 date, I don't find the date.
I will give you date.
17.
17/2024.
Yes.
17/2024. The respondent is before this court. The petitioner herein, the respondent herein had filed the suit, has filed the MC seeking a divorce on the ground of cruelty, on the ground of adultery and other grounds, whereas the wife had filed her counterclaim seeking restitution of conjugal rights. While The application for maintenance filed by the wife is coming up for hearing. At that point of time, these applications are filed under Order 7, Rule 14, read with 151 CPC. It is a case that it is a case of the husband that initially, no, it is not adultery, it's on the ground of nullity.
On the ground of not consummation.
The husband has filed the MC on the ground.
It's also on the
seeking
ground of
divorce
adult.
on the ground of
Also on the
nullity
ground of
due
adult.
to non-consummation of the marriage. The initially Xerox copies of the documents were submitted with the petition. Subsequently, authenticated data, images, messages, audio and videos from respondents, the wife's phone number were obtained from a forensic expert. Under Section 45 of the Evidence Act. These documents are crucial for the case and are admissible under Section 3 of the Indian Evidence Act. How can you yourself get a report if it's for the court?
Your lordship, from the mobile, I have taken printout.
No, when you have to file, though, under which provision that you have taken that?
65B, your lordship.
Admittedly, it is my mobile. How he can take the printout and other things from my mobile? Unless I authorize him to take it. How this false case has
How
been
can it
treated?
be?
Your lordship, because the adultery committed by her,
No, but the phone belongs to her.
please, your lordship.
How will you, like, that's her phone number. The device is with her.
Please, your lordship, in the matrimonial tie, your lordship, these kind of things cannot happen because she cannot do whatever she wants in
But
such a way.
there is a procedure for everything. That certificate under 65, who has to give? Whose instrument is that?
Because the instrument is purchased by me only,
Used by her.
used by her.
And videos from the phone number of the respondent from a forensic expert under Section 45 of the Evidence Act. And they are the crucial documents for the case under admissible under Section 3 of the Evidence Act. The wife had filed her objections. And it is stated that the application to introduce irrelevant and manipulated documents at this stage is not maintainable, as the case has not yet proceeded to the evidence stage. The petitioner's claims in the affidavit are false. The claim of the husband in the affidavit are false. And to produce any of the document is up to the court and not to the petitioner to determine the admissibility and relevance of the evidence. The forensic expert cited by the petitioner is not credible. The documents were created post petition to damage the reputation of the wife. She requested the court to reject the application for lack of grounds and question the for lack of grounds. The trial court had allowed the said application. Stating that the party submitting the evidence must typically provide a certificate under Section 65B of the Indian Evidence Act, attesting to the authenticity of the electronic record. When a document marked through an expert, such as forensic analyst, can be brought into authentic and analyze electronic evidence, an expert's testimony can help establish the reliability and authenticity of the evidence. The forensic experts often provide detailed reports and may be called to testify about their findings, methods, and the integrity of the electronic evidence. It is the court observed that the admissibility and marking of electronic evidence are governed by specific rules, and courts often prefer evidence to be accompanied by expert analysis to ensure its authenticity and reliability. After production of the document, the respondent will get the opportunity to deny the document through cross-examination of PW1 and accordingly dismissed. Agreed thereby the wife is before this court. Learned counsel submits that the court below ought not to have admitted such a document. He had relied on section 45 of the Evidence Act, section 45 and section 45A of the Evidence Act. He had also relied on section 70, extract that sections. He had relied on section 79A of the Information Technology Act 2000. It is stated that the central government, by relying on the said judgment, the said provision, Land Council submits that the central government, for the purpose of providing expert opinion on electronic form evidence before any court or other authority specification in the official gazette, any department, body or agency of the central government or a state government as an examiner of electronic evidence, he submits that they have also filed their objections about the authenticity of the said expert. Further, it is submitted that the said device belonged to the petitioner, the wife, but not to the respondent.
Permitted to attend the
Huh?
other court. I may be permitted to attend the other court.
Huh?
I may be permitted to attend the other court where my matter
Yes.
is, please.
It belongs to the respondent wife, and the court below ought not to have allowed such an application. Next, Land Council appearing for the respondent submits that once this is allowed, the wife would get an opportunity to cross-examine and cross-examine and without availing the same, the wife had come before this court for filing this writ petition. And the writ petition is reserved to be dismissed. In this case, this court, having heard the counsels on either side, peruse the material on record. The electronic evidence which he wants to produce is from the phone of the wife, which she has been using. Now, at this stage, the application and the court, there is no whisper in the entire order about that belongs to, the phone belongs to whom. And how that is in the possession of the husband, and other issues are not at all decided by the court. When the phone belongs to the wife and she is in possession of it, and how come the husband had all these the photographs and other whatever the electronic evidence that he is referring to, nothing has been discussed by the court. The considered opinion of this court, just like that, allowing an application and basing on the certificate that is obtained from an expert by the husband, the court cannot just like that allow the applications. In that view of the matter, this application, this IA number, the present impugned order needs to be set aside. It is left open to the parties to come at an appropriate stage to come up with an appropriate application. And in that application, the court shall decide the same.
Yes.
The senior counsel matter call.
Last over matter, serial number 1. Over matter, serial number 1.
Sorry, my lord, I'm on my leg in the other court at 10:30. I'm sorry, ma'am. Notes ಕೊಟ್ನಲ್ಲ.
Yes.
Just I pass on a small notes for your lordship study economic.
Yes. Take that.
What do you have? Okay. Can I take your lordship's minute?
Yes.
Lord, this writ petition is filed challenging the order dated 10/10/2017, passed on IA number 1/16 in FTP 88. On the same day, my lord, one more application was also rejected in execution 2371 of 2012. These are the impugned orders. My lord, how matter came up before lordship is, one Bettai Shetty had 4 sons, namely Lakshmi Narayana Shetty, Ramakrishna Shetty, Venkatramaya Shetty, and Venkatraga. All the 4 sons are no more. Then my lord, OS 5590 of 96 was filed by the family members claiming 1/10 share in related to A, B, and C schedule property. C property were dismissed. 26/7/2006, above said suit 5590/96 were decreed, holding that plaintiffs are entitled for 1/10 share. FDP 88 of 2006 was initiated by the decree holder, Srimati Rajalakshmi and others, related to A and B schedule properties. Since there is no dispute to schedule A property, this writ petition is nothing to do for the same. Then my lord, the schedule B property is 17 point, number 17, 5th cross New Kalasi Palyam extension, Bangalore, measuring east to west 30 feet, north to south 80 feet, consisting with 2 floors, totally measuring 2,400 square feet. It's a commercial property. According to the preliminary decree, each sharer is entitled for 1/10 share. Therefore, B schedule is concerned, sharer is entitled for 240 square foot, both in ground floor and the first floor. Preliminary decree was assigned in RFA 2411 of 2006.
I've seen that. Now, who is the petitioner before this court?
He was one of the sharer.
Is
Who's-
added as defendant number?
He is the, he was the for respondent in the final decree proceedings. Respondent number 3, in the final decree proceedings, he is no more and his LRs are now on record.
Yes.
My lord, the subject, I would not take your lordship's much time. The controversy, we pressed in 2 applications. It is, my lord, with reference to, we sought for permission of the court to ask the other side to withdraw the deposit, as we are wanted to have our share of 240 square feet physically. That was the application we moved before the FDP court in FDP. And the execution, there was a delivery warrant process was there. Therefore, we moved, since that application is pending before the final decree proceeding, please stay the further proceedings in execution is the application we moved there. These 2 applications were rejected by the executing court and the final decree.
Yes, IA number.
IA number 1, my lord, 1 minute, I come back to a lordship's minute.
Please come to the order straight away.
Yes.
IA number 1/16.
Huh?
IA number 1/16.
IA number
1/16.
1/58.
16, 1/16.
My lord, your lordship will get that order at page 72. Page 72, annexure L.
Order that.
Page 72, annexure L, sir. And ಹೇಳಿದ್ದೀನಿ, sir, don't worry.
Yes.
If I tell the wrong, you please correct me.
No, I'll only assisted the court.
Yes.
Yes, IA
The
number.
page 72, annexure L is the order.
Yes.
The respondent 3 has filed the above IA under section 151 of CPC, seeking permission to retain his share of the property, permit or direct auction purchase to withdraw the money deposited by him without claiming the share of the 3rd respondent. In the affidavit, 3rd respondent has stated that petitioner to have initiated final decree proceedings in pursuance of the judgment and decree passed by the court. The above petition is said to have been filed, seeking for delivery of the possession of the property to the extent of their respective share as a matter of convenience, and to the difficulty of apportionment of properties. It was said to be decided that sued property would be sold for valuable sale consideration, and sale proceeds would be allotted to the shareholders. Auction purchasers said to be shareholders, interested parties to sue schedule item and taking advantage of the situation and misunderstanding prevailing among them. Decree holders are said to have not deposited the sale proceeds amount in time, that it was not allotted delivered to them. Therefore, there is said to be an inordinate delay, and no benefit would be derived to him even after deposit as the value of the said property later stage, as all them are said to be related to each other. It is said to be appropriate to keep the property to the extent of share that is allotted to him, safeguard the interest of the family members. In case the petitioners are said to be allowed to take physical possession of the property, including his share, it's said to cause untold hardship. He is said to have 2 sons, and a portion of the scheduled property by way of share is to be allotted to him. It is said to be benefit his son so larger extent of future that they would be in a position to enjoy the property as their ancestral property. Portion of the property that was developed and constructed by him, it is said to be divided without any difficulty. Interest or duty sought for. The petitioner number 5 has filed a counter to the affidavit by way of objection to the IA, stating that FDP, a public auction to have taken held on 35/2011, appointing a court commissioner to sell the B schedule property. In that auction 35/2011, he is a sharers were sold to be permitted to bid auction. Highest bid was 1,17 lakhs was sold, said to have been offered by himself. This was accepted by his sisters. Thereafterwards, sale certificate was said to have been issued on 8/6/2012 in favor of the auction purchaser. Petitioner 225 in regard to the suit schedule property. Petitioners are said to have deposited the amount to the court by deducting their share amount. Thereafterwards, they are said to have made an application seeking issuance of certificate pertaining to B schedule property. They are sold to have purchased the same in public auction. The court is said to have passed an order 11/11/2011 directing issuance of sale certificate to the petitioner 225. Thereafter, sale certificate was said to be issued by the court. It is said to have been duly registered in favor of the petitioner. Third respondent, who is said to be his brother, is said to have participated in the proceedings as well as before this court in so and so, challenged the public auction as well as sale certificate. Therefore, third respondent is said to be estopped from seeking any relief to retain his share in B schedule property by way of application in the above FDP. Memo of calculation was said to have been filed by the petitioner of so and so. Court is said to have ordered for payment of so and so, stating that 10 lakhs, 10 crores, 85 lakhs, 182, 95 paise to be held in the court until the possession of the first floor of property has been delivered to the petitioner 225 by the third respondent. Third respondent is said to be not entitled to make any claim pertaining to his share in respect of B schedule property. The claim of third respondent, if any, is said to be restrained to amount 10 crores 85 lakh, 10 lakhs 85,182 in the court deposit subject to deduction, etc. Then reasons. 6 paragraph. The above OA dated 6/11/2016, numbered in IA 1 of 16, is filed by the third respondent seeking and permit the auction purchaser to withdraw the amount deposited by him without claiming the share of the third respondent. The above FDP has been filed in pursuant of decree passed in so and so. There is already an order from this court regarding memo of calculation dated so and so. It is reported it may not be necessary. Lord, may kindly go to next page. RFA 649 of 2000 was preferred against the order dated 11/11/2011, passed on IA number 427 in the above case. That appeal was dismissed as infectious. It is an admitted fact that from the nature of the objections to the above IA, petitioner that claim of the third respondent to be restricted only to so and so amount, subject to deduction of corporation taxes, electricity bill, etc., surrendering the vacant possession of first floor of B schedule property to auction purchasers, namely petitioner number 225. It is unclear from the records before the court as well as in the affidavit to the above IA if the said order dated 17/9/2014 has been complied or not, when there is already an order as to the share of the third respondent to be held in the court, and then again passing an order on the very same day. Claim of third respondent cannot arise. There is an order that share of the third respondent is to be handed over only after possession is delivered to the petitioner number 224 pertaining to first floor of the property. Such being the case, prayer as fought for in IA number cannot be permitted at this stage. Nature of the prayer sought for, etc. is, then IA is rejected, my lord, that is the operative portion. Then one more order is passed at page annexure M, page 80, my lord. This is in the execution proceedings. It is also on IA number 1 of 2016, filed under order 21 rule 29 of CPC. Consequences of the order passed earlier. This order was passed rejecting my application, stay the proceedings. These two orders are assailed by me before your lordships in the present writ petition. My lord, in the meantime, an amendment application was moved in the writ petition, my lord, may kindly be seen. That application is still pending.
Where is this order in RFA number 2411 of 2006 is filed before the court?
RFA 2411, my lord, I think. It is at page 32, annexure C.
Page 32.
Page 32, annexure C. What do you lordships, my lord?
Yes.
This is dated, my lord, 24th July 2008.
Hmm.
Can I read operative portion of the
Yes.
order? May I take your lordship to paragraph 5 at page 35?
Yes. Yes.
In view of the above said fact, the compromise petition filed under order 23 CPC is allowed. Judgment and decree passed in trial court is appeal is modified. Decree shall be passed in terms of the compromise. Insofar as clause 18 compromise petition is concerned, time fixed is 10/4/2000 shall be read or 30/11/2008.
Can we see that compromise memo?
Compromise, my lord. My lord, it is page 24, annexure B. This is in respect of A schedule property is concerned, which is nothing to do with the writ petition is concerned. It is related to B schedule property.
Then A schedule property,
A
whatever.
schedule property, there is no dispute. It have been divided. They are enjoying peacefully and happily.
B schedule property is concerned, then the judgment decree of the trial court holds good.
Yes, absolutely. no
Where is the judgment decree of the trial court?
Lord, that we have not placed on recordment.
So that is relevant now. Now, are you permitted to take all these grounds later? What is the judgment? and
My lord,
decree?
it's a simple legal issue I have raised. There would not be any reason to scratch anybody's head and the factual aspects are concerned. B schedule property is concerned, preliminary decree indicates that each sharer is entitled for 1/10 share. 1/10 share would comes to 240 square foot, which includes of the first floor and the ground floor. I am also entitled one of the sharer of the 1/10 share is concerned. Then, my lord, this sought to be divided.
What is the nature of the property?
Beg your lord.
Nature of the property.
Commercial property is 30 into 80, it is about 2,400 square foot. 2,400 square foot. My lord, the sharers, it is sought to be divided physically between the parties when it found to be not possible. Then it is decided an order was passed to sell the property and usufruct to be divided among the family members. accordingly, auction have taken place. Now, the question before your lordships, which I have raised in the writ petition is, an auction have taken place, it is under order or 21 rule 85 or CPC only. Order 21 rule 85 contemplates that an auction purchaser is required to make a deposit of 25% on the date of the action. 75% to be deposited on the before expiry of the 15th day of the auction. If the auction deposit has not complied with the requirement, neither the court nor anybody else in this world having power to extend the time. That was the language employed by the Supreme Court in a later judgment.
No, on 2011, a sales certificate is.
Sale
issued
certificate was
and it
issued
was
even before depositing the amount.
registered on 15th.
Correct, even before depositing the amount. That is the reason we challenge the sale certificate. Now the question is.
What did you say in this IAS before the court about this not depositing the amount under where is
We said that is the reason. We raised an amendment application.
No,
may
not
kindly be-
here, before the court below.
May I just make persuade your lordships
Yes.
on this application pending before your lordships. I wanted to, this of course, IA we have filed, I can show you to your lordships the application. May I kindly see, my lord, the application at page 58,
58.
Annexure G. Then, court. That for the reasons stated in the accompanying affidavit, the respondent number 3 above named prayer that this honorable court be pleased to permit him to retain his share in the property and permit or direct the auction purchase to withdraw the money deposited by the without claiming the share of the respondent number 3 in the interest of justice. This is the application we have moved. Then affidavit is there at the next page.
Where is it mentioned about all these, just know what you have submitted?
My lord, these facts, of course, not directly brought in this application. This is
one
not brought in this application. That is the reason. In the writ petition, my lord, I made an application for amendment. I raised that issue.
No, thing is, this court is exercising the jurisdiction on 227.
Correct.
What is the ground, what is the application filed by you?
Correct.
What is the order passed by the?
Correct.
So let's see what are the grounds there.
Correct, I can,
No, there is a question
may I
of
take
no
your
amending
lordships
it.
to the affidavit at page 59, my lord?
We look at it.
Can I
Please,
take your lordships
Yes.
paragraph 4, my lord?
Yes, please.
Further said that as a matter of convenience and to overcome difficulty of apportionment of the property, it was decided that the associated property should be sold for a valuable sale consideration. Sale proceeds would be allotted to the shareholders. It is pertinent to state that at this juncture that the auction purchaser is also shareholders, interested parties in the suit schedule, items of taking advantage of a situation of misunderstanding prevailing among them. The decree holder did not deposit the sale consideration amount on and when it was allotted and delivered to us. The inordinate delay and no benefit could be derived to me even after the deposit of the value of the scheduled property before this court. I state that it is not appropriate at this junction to receive or take share in terms of money. Since we are all related to each other, it would be appropriate to keep the property to the extent of share that is allotted to me, safeguard the interest of my family members. I wish to hold immutable property to the extent of my share only in the given facts and circumstances without accepting my share in terms of money. I state that if the petitioners are allowed to take the physical possession of the property, including my share, my family persons will be put to untold hardship. This is the contents of my application. Incidentally, I said there is an inordinate delay in making the deposit.
When was the auction conducted? Can you please tell the date?
Beg your lordship.
When was the auction?
Yes,
conducted?
auction scheduled on. Whether my notes may kindly be having.
In that it is mentioned.
Paragraph 14, I make it take.
Yes.
Paragraph 14. 35/2011, the date of auction. Highest bid has to be deposited at 25%. 14/6/2011, 15 days expires. Neither 25% nor 75% were deposited in terms of order 21 rule 85, 86, etc. 8/6/2011, highest bidder filed a memo before executing court to deposit the amount. 11/7/2011, the amount was deposited as per the memo of 69,49,945. Said amount are deposited on 21/7/2011. This is the time schedule.
Yes.
My lord, in this context, only now I filed an amendment application before your lordships seeking amendment to the petition raising this ground.
I will go to that. Now, another factually, what the court wants to know is, this amount is deposited on 21/7/2011.
Correct.
Then the 11/11/2011.
They filed a memo.
Issuance of sales certificate on
No,
11.
no, yes.
11/11, that is
Correct.
after the money is
Correct.
paid.
No, no,
No,
no,
yes.
no. It is not after the money is deposited, before the money is deposited. Because sales certificate was issued in June 2011. Amount was deposited in July 2011.
It is not 11/11/2011?
No, 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 11, not 11.
No,
It
please
is
come to
11,
the
11.
earlier order which you were.
Oh,
reading,
yes.
I think it has a reference to that.
1 minute.
Please come
I
to the
can- I
order.
can clarify that. If I may be wrong, I can correct myself.
Please come to page 74. Page 74.
1 minute, my lord. Yes, yes,
From bottom about 5 lines.
yes. Said to have passed an order
On
directing issuance of the sales certificate on 11/11/2011. Yes, subsequent. Sorry, my lord.
And then after that,
Yes.
after this 11/11/2011.
Yes.
Or a sale certificate is registered on 15/6/2012.
Correct.
Then from 2012 till 2016, what was pending before the court?
My lord, the execution proceedings are pending and delivery warrant process is also pending.
No. Was this sales certificate that was issued, which is contrary to the provisions of the CPC, was it questioned by the third respondent?
Yes, we said,
Where is that?
my lord, we said your lordships may
Not
kindly
here,
say in our
not in
application.
this,
In our application, sales certificate ought not to have been issued because of belated
No,
payment.
not this certificate. When the sales certificate was issued, when you are part of a final decree proceedings, did you question that sales
No,
certificate?
it was
On the
not.
ground that these are all the
It was not,
irregularities. So it has attained finality.
Correct, correct.
Yes.
My submission is, may kindly make a note of my concepts. Concept is this: issuance of sales certificate, delivery of possession in favor of an auction purchaser, even before deposit or after deposit, would not come in the way of seeking vitiating of the proceedings in a case where amount deposited to be deposited not within the time stipulated under Order 21, Rule 85 and 86.
Yes.
Effect of non-deposit, as explained by the High Supreme Court, is it is a nullity in the eye of law. It is a void transaction.
Yes.
Further, the Supreme Court said, in the light of Order 21, Rule 86 itself, when one such a deposit not made, court have no other option except to go for the re-auction. This is the legal consequences. Only because if I have not challenged, sales certificate was issued, it is registered, all these things would not validate a nullity action, which is failure to make a deposit within 15 days.
Yes.
This is the precise question I have raised in my application for amendment. It was not clearly raised in before the trial court. I improved my case before your lordships, making that things very clarity and supplementing the legal issues also. That's all that was the issue before your lordships.
Yes.
My lord, in fact, this matter was heard by the other bench. Other side was put to the question. Since the nullity is there, if you want to settle the matter, you can settle it. They never come forward, or if they come forward, they wanted to offer a peanut. Of course, my client is not inclined. These are all the developments have taken place. Even matter was heard by the two benches. The Lordship Justice Nataraj Rangaswamy have also heard the matter. I think this fact would not have been disputed by learned friend.
Yes.
Then, my lord, this is the legal issue. Then your lordship, could your lordship may kindly have that amendment application for a moment, my lord.
Yes.
This is still yet to be allowed. It is not yet allowed.
We'll, along with the main petition itself, we'll pass the order.
Yes.
On the amendment petition.
Very well, my lord. We have no grievance at all.
Yes.
Only thing is that issue to be addressed. Whole heart of the case, it depends upon that amendment only. That's what my endeavor is that, my lord.
Yes.
Don't mistake upon me.
Yes.
That's the reason I am pressurizing on the
Yes.
application
Yes,
is
yes, I
concerned,
understand.
because a legal issue I wanted to raise.
Yes. Yes, this.
My lord, this is IA number 1 of 2018 is the application for amendment.
Yes. 1 of 19.
Yes, 1 of 18.
But it appears to be 1 of. Oh, it's 1 of 18.
Am I right, I think? Lord, in which I narrated certain facts at paragraph 10A, at page 2 of para 2 of my amendment application 10A.
Yes.
I refer to this date of auction and all other things, my lord.
Yes.
Then, my lord, para 11A,
Yes.
I refer to the imperative of 25% and other things.
Yes.
15F, my lord, is the legal issue.
Yes.
Under Indian Partition Act, no separate procedure is contemplated so far as action of the property is concerned. Therefore, any provision available in Partition Act is only an enabling provision for procedural aspects are concerned. Procedure contemplated in CPC is required to be followed. Under Order 21, Rule 84, 85, 86, 90 of CPC, a procedure is contemplated so far as conducting the auction, making deposit of the bid amount is concerned. According to the said provision, on the date of bid, highest bidder has to deposit 25% of the bid amount. 75% shall be deposited on or before 15th day. In the instant case, date of auction was 35/2011. 15 days expires on 14/6/2011. Admittedly, memo have been filed by the executing court seeking leave to deposit on 8/6. Ultimately, amount was deposited as per the memo dated 11/7/2011. Actually, the said amount was deposited on 21/7/2011. This is against the scope. Then I refer to the judgment of the Supreme Court in 1996, 5 SCC, 2012, 13 SCC. I refer to. Then with the latest judgment on the point, my lord, your lordships may kindly see. This is 2023, 6 SCC, my lord, page 596, 391.
Yes.
Can I take your lordship's, my lord?
Yes.
As decree was not executed, decree holder filed execution. Proceedings property in question was put to auction. Purchaser R1 deposited 25% of bid or not deposited 25% as required under Order 21 Rule 84. Auction purchaser required to deposit 25% of the amount. Day on which he was declared the purchaser. Even balance 75 to be not been deposited as required under Order 21. Full amount of purchase money in the present case has been deposited of the period prescribed. Thus, there is no non-compliance. Therefore, sale is vitiated. Lord, the legal issue was analyzed from paragraph 36 to 21, 31.
Yes.
26 to 31.
Yes.
Lord, your lordship may kindly go to page 395.
Yes.
Order 84, 85 and 26 are explained.
Yes.
Then 24, 25, my lord, again legal issues.
Yes.
Para 26 may kindly be seen. In the present case, admittedly, the purchaser respondent 1 deposited 25% of the amount on so and so, did not deposit 25% amount as required under so and so. Auction purchaser required to deposit 25% of the amount the day on which he was declared purchaser. Even balance 75% of the has not been deposited as required. Full amount of the purchase money in the present case has been deposited and so and so after the period prescribed. Therefore, it is non-compliant. In the light of the aforesaid few decisions of this court is referred to, that is Manilal Mohanlal's case, then para 29 again mirrored Mohanlal's case. All other things are referred to. Yes. Ultimately, at para 31, applying the law laid down by this court in the aforesaid decision fact in hand, evident that their non-compliance of mandatory provisions, Rule 85, therefore sale was vitiated. Then it is further explained by the Supreme Court that though no other options are available to the executing court except to re-auction the property. My lord, it is my submission would be, I am not disturbing or I am not holding the brief for the other sharers. My share is 1/10. 1/10 is 240 square foot. I confined it only 240, and any proceedings, it will be only in respect of that is, I am not intended to disturb other cities between themselves, my lord. I have no complaint at all. This is my fair stand on the issue is concerned. Despite nullity or not, it would not affect their case because they are not before these lordships now. The complaint is by a person who is affected by impugned order. His complaint I am addressing that, sir. My lord, all these judgment, my lord, I pass on the compendium of the
It's
judgment.
there, I've seen already. It is there along with the.
Yes,
this file.
it is
I've seen that. Yes.
The lordship may kindly have annexed G, page 58 per number.
Annexion,
G.
page number.
58.
Yes.
Stating the accompanying affidavit to the respond number 3 with the petition hearing. Name phrase that this honorable court may be pleased to permit you to retain his share in the property and permit or direct the auction purchaser to withdraw the money deposited by the court without claiming the share of respond number 3 in the interest.
I've seen that.
Your lordship may kindly immediately go to annexure B, page 28.
Page number.
28.
Yes,
Annexure
sir.
B actually starts from, annexure B starts from page number 24. 24. You lordship may
Compromise
direct- no,
application.
Directly, you lordship may go to page 28. Thank you. My friend, I have already read the order. So para 8 is not concerned with the A schedule property. B is concerned, you lordship may kindly at para 9.
Para 8, my lord.
Para 8 is concerned, it is pertaining to A schedule. Your Honor,
No, 8 is also referred to B schedule property. May I read it, sir?
Right. Your Honor, kindly, I read it. Appellant, respondent, and mutual agree that B schedule property cannot be divided equally among themselves and
Correct.
cannot be put into separate possession, and thereby appellant respondents have agreed to sell B schedule property in public auction in FTP number 88 of 2000 pending before the Honorable Supreme Court, Bangalore, within 10/4/2010 by extending full cooperation with themselves. Then your lordship may go to the appellant and respondent mutually agree to divide the sale proceeds among themselves according to the share declared by the criminal decree after deducting the legal expenses of the sale of the B schedule property in public auction. Appellant and respondent are entitled to bid the public auction. You are entitled to bid the public auction. Sisters have bid the public auction, and there is a successful. Then your lordship may. Therefore, contrary to the compromise memo filed before the division bench, they cannot contend, I want to retain the share. Petitioner cannot say for a moment, no, I want to retain the share, because in the compromise decree, he specifically agreed. He is entitled for a money or entitled to bid in the auction. He is not bid in the auction between the family members, and public also participated. Auction purchasers are the highest, the sisters are the highest bidders. Daughters were the highest bidders, his sisters are highest bidders, we have purchased the property. Some of these brothers already taken the money, and some of the sisters have filed vouchers, and because of the state, they are not able to get the money. That's the crux of the matter. Then, therefore, the trial court has rightly rejected it. You cannot have a contrary stand. Once you are agreed that I am entitled to money, then you come back and say, I want to retain the property. That's nothing. He should have participated in the public auction and bid the auction. No, he has not participated in the public auction. He was present, he has not bid the public auction. Therefore, there is no illegality in the order passed. The jurisdiction is a very limited jurisdiction, like a civil court, civil CRP jurisdiction. Therefore, the court cannot interfere when there is no illegality at all. It has to be in a writ jurisdiction, supervisory jurisdiction. Therefore, it cannot be interfered with. Then your lordship may kindly, as far deposit is concerned.
Yes.
Right, action was held on 35/2011,
And memo was filed on 15/6/2011, requesting the court, I want to retain my share amount may be deducted. No order was passed on that. Therefore, we made an application under order 21 rule 84, IA number 2/11, 2/11. Under order 21 rule 84 CPC, seeking for deposit auction money after deducting their after deducting their 1/10 share. Respondent 1/6 and date I made an application. Another application was filed under section 151, CPC expenses of public auction, IA number 3/11. The order was passed. Your lordship may kindly go to page, I filed detailed objection to writ petition. Your lordship may kindly go to page 31.
51 of your objections.
Page 31. Now, along with that, my petition statement.
It's no 51, I think, the page.
Here, along with the objection statement to writ petition, my document. For the record.
These objections are there. You are saying something about 50? Page number?
Page number, you know, my objection start, page number, lordship may have that. Page number 27, your lordship may have.
20?
32, sorry, 32, 37.
Because there is no 52 in that.
32.
Yes,
Lordship got that order.
yes.
The case called out, petitioner and respondent 2 to 5 present, IA number 2 and 3/11. IA 2/11, the petitioner 2 to 5 have purchased.
No,
property.
page number 33 are the checks.
32.
32.
That is the record of
Yes,
deposit.
yes.
IA number 2/11, petition 2 to 5 have purchased the suit property in public auction with the sanction of the court for a total sum of rupees 1 crore 17 lakhs. Now they want to deduct their 1/10 share each, which amounts to 46,000, 46 lakh 80,000 out of the said bid amount before depositing the bid
I
amount.
think even that number is also not correct. It's a memo. 32 is a memo.
Sir, we got 32 is an order. R3, your lordship will tell you. Annexure R3. R3. That's your lordship, my objection. to
I'm
the
looking at
writ
your
petition.
objections only.
R3.
Objection to the application.
R3 order sheet. 24/9/2019. R3. He is referring to, it's a court order. May I take it and read? R3. FTP 88 order sheet.
Order sheet.
The lordship may go to
yes.
next page. Case called.
Yes.
The petitioner and respondent 2 to 5 present, peruse IA number 2 and 3. IA number 2/11, the petitioner 2 to 5 have purchased the suit property in public auction with the sanction of the court for a total consideration of 1 crore 17 lakh. Now they want to deduct their 1/10 share each, which amounts to 46 lakhs 80,000 out of the bid amount before depositing the bid amount in the case. The prayer, the said prayer is lawful and justified. Therefore, IA number 2/11 is allowed. The petition 2 to 5 are permitted to deduct their share amount from the total bid amount and deposit only the balance. IA number 3/11. The petitioner 2 to 5 seeking deduct 70,058 towards the expenditure met for the auction of the property. The said cost towards advertising expenses of 55,758, which is supported by some bill, printing pamphlet that 10 days. Then 2 to 3 are permitted, your lordship early. Supported by the bill advertisement of newspaper, sale material on record. The total is 70,000. Obviously, petition 2 to 5 are entitled to deduction of the said amount. They are permitted to deduct the said amount before they are deposited the bid amount. The petition 2 to 5 shall deposit the balance amount with a memo under the memo of calculation in the office. Call on. That is the order. This order was passed on 27/6/2011. Then you lordship may kindly see with regard to deposit, memo has been, I have stated in the memo how the amount has been deposited.
Yes.
That is petition 225 hereby deposit auction sale price of 69,000.
Dates are given.
Dates
Yes.
are given. Then.
It's on 7/7/2011.
Right. If this pay order that is having. No. This order is not under challenge. The petitioner before this court is the respond number 3 there, he has not challenged this order that has been concluded against him. Therefore, he cannot have any grievance unless he challenges this order. Court has permitted. Court has powers under the Partition Act. I will coordinate bench of this court has decided this issue. I have pointed out that. And the court has permitted because we are the suit is for partition before the family members. The family members are entitled to bid in public auction without deposit. Even the court has permitted. The High Court has permitted, trial court has permitted to bid the public auction. We bid the public auction. Therefore, we have deposited the amount. There is no order, he is not under challenge. Once it's concluded order, he cannot revert back and say, you not deposited that time. Then your own may, you lost.
So according to him, that proceedings itself for nullity, it can be questioned in any proceedings.
Nullity is a question in any proceeding.
That's what is his
If
submission.
it is a nullity is question in any proceeding, I know that. You lost him kindly have, these all issues has been answered.
Take that.
ನಿಮ್ಗೆ ಕೊಟ್ಟಾಗಿದೆ ಲಾಸ್ಟ್ ಹಿಯರಿಂಗ್ ಕೊಟ್ಟಿದೆ ಏನು ಹೆಸರು ಹೇಳಿ ಪಾರ್ಟಿ ಹೆಸರು ಆರ್ಡರ್ ನಿಮ್ಗೆ ಕಾಪಿನೇ ಕೊಟ್ಟಿದ್ದೀನಿ ಸರ್.
Yes.
You lost me directly good because this issue is answered at para 10 you lost me para 10.
Yes.
Para 10. We heard the counsel appearing for the petitioner and the learned counsel appearing for the respondent 15. Peruse the order under challenge. The following points would arise for consideration. Whether the provisions under Order 24, Rule 84 CPC are applicable to the auction conducted under Section 3 of the Partition Act. They cannot dispute it between the family members also. Whether the petitioners have made out a case for setting aside the auction on the ground that they were not offered an opportunity to participate in the auction. Then you lost me kindly reason. The present petitioner, the petition objection is the respond number 15 as filed to deposit 50% of the bid amount as on the date of action. Therefore, the petitioner contended that it is mandatory to deposit 25% amount on the date of auction and the successful bidder has to pay the entire amount within 15 days, that is 4/12/21. Learned counsel respond number 15 has placed reliance on the judgment rendered by the High Court of Andhra Pradesh in the case of Bharat Ratnam Satyanarayana. Identical case, the High Court of Andhra Pradesh was of the view that in case sale under Section 3 and 4, the Section 3 and 4, the sale of the shares of the other shareholders in favor of the shareholders applying for the purchasers governed by the self-contained procedure under Section 3 and 4 only, and such a necessary or proper direction as the court may grant and not by the procedure under section which are directly in nature. The High Court in the above said judgment was also view that the court is vested with a discretion to extend the time for depositing the amount towards the sale of the shares of the other sharers without reference to the provisions of Order 21 Rule 84 CPC. Similarly, also taken by the Madras High Court in the case of Vivekananda versus Vijay Kumar. The High Court of Madras is also view so auction sale conducted under the provisions of Partition Act not attract the procedures contemplated under Order 21 CPC. The Madras High Court also of the view these provision has to be followed only as the guidelines and it is not
Please come to para 14.
Para 14. The provision regarding deposit of 25% of purchaser other than the decree holder is a mandatory non-compliance will make it sale nullity. Therefore, the court of the view that the provisions of Order 21 Rule 84 would apply when there is a public auction of the property, where a property is sold under the provision of the Partition Act, rules do not apply, and the court can extend the time of payment of deposit in exercise of inherent powers. The strict compliance of Order 21 Rule 84 and 85 cannot be extended to the action conducted conducted under the, in a public auction. If a bid is accepted and offer conducted, the sale is not complete in deposit 25% of the purchase amount, it cannot be placed before the court the formal acceptance and declaration of the purchase. Another reason imposed for requirement of the initial deposit is immediately after the bid is accepted. The safeguard against the reckless collusive bids. Therefore, the immediate initial deposit 25% to ensure the participant in the public action demonstrate bona fide. Initial deposit 25% is only to see the auction purchaser really interested in purchasing the property, but auction purchaser ultimately leads to the satisfaction of the decree under the executing code. The sixth compliance of Article 21 cannot be applied to the co-sharers. I don't know, co-sharers invoked the provision of the Partition Act. Like when a stranger purchases the public auction, co-sharer himself has pre-existing rights. The party is given option to go auction to see that the intrinsic value of the suit property. It's a public auction. It is an auction between the parties.
Who are you, the purchaser?
We are the sisters, petitioner sisters.
Yes.
Therefore, applying this rule, I think the second, the lordship may kindly see this amendment, when this amendment is sought. Your lordship.
Which amendment, amendment in this writ petition?
Lordship may come to another judgment.
In 2018, 18 this is sought. Amendment is sought.
I'll just say, find out that amendment is concerned. Your lordship may kindly have.
Yes.
I'll go back. Sir. Directly go, your lordship may go to 342 page. 242.
Yes.
Under Article 21 Rule 82, under Article 21 Rule 92, 89, 90, 91 and 94, the court sale in execution by decree, it becomes absolute. Once the sale is confirmed, the sale certificate issued in favor of the purchaser, sale shall become final. Interference with such a sale would, which has become final, whether permissible. The court said no.
Please come to which is the para with regard to that head note E.
Head note E. 45 and 46. May I take another? Your lordship, I kindly have page 243.
240?
243. 243.
That is its starting of the judgment.
Starting of the judgment. Then your lordship may kindly go to as per the relevant provisions of CPC, more particularly Article 21 Rule 92. That is Article 21 Rule 81. Once the sale is confirmed, the sale certificate has been issued in favor of the purchaser, the same shall become final. Para 34.
Para 34.
That is your lordship may read it at page 243.
Para 34.
As per the relevant provision of CPC, your lordship pointed. As per the relevant provision of CPC, more particularly Article 21 Rule 92, that with Section 21, Article 21 Rule 94, once the sale is confirmed and the sale certificate has been issued in favor of the purchaser, the same shall become final. Lordship got that?
How is it relevant here?
Page 34.
This is on the ground of fraud and other things. That is on the ground of fraud.
Right. Here, your lordship, they say that CPC is not applicable because it's an option between the family members. No fraud has
On
been
that
alleged.
judgment, yes.
No fraud has been alleged against the petitioner.
Yes.
And they want to seek this amendment. Your lordship may kindly see the orders is one thing. The order pass, including order pass is one thing. But the amendment is sought for is different, altogether different. They have not paid in any application, Article 21 Rule 88 for setting aside the sale. That application required to be filed within 60 days.
Yes,
They have not filed such application before the court.
yes.
Secondly, they have, once the sale has been confirmed under order, confirmed under order 21 rule 92 applicable, sale has become concluded, read with section 65 CPC, we have become absolute owners of the property.
Yes.
Therefore, sale certificate also produced before the court. Sale certificate has been produced.
I've seen. Awesome.
Sorry.
Yes, I'll dictate the order in the afternoon.
Can I make one?
Yes,
Just
pin this.
and there is one Supreme Court. May I request your lordship to look at the comparison which you have placed on record. One minute. They cited a Supreme Court ruling.
What is that?
My friend has cited a Supreme Court ruling. That ruling is not applicable. There's a money decree between the parties there. Their auction purchase is the purchaser. Here is a partition suit between the co-sharers. That's not applicable.
I'll dictate.
Milord, can I persuade you?
Yes.
The judgment compendium filed on 7 September 2021, page 24 may kindly be seen. This is a judgment
No,
of the Apex Court
in the
reported in
repetition itself it is there.
2012,
Yes.
13 SCC, page 568.
What in that? Give the file. They filed along with the red petition. Give the red
7
petition.
September 21.
Yes, yes, I've seen that. Yes. Again, we'll look at that. Yes. Yes.
May kindly go to page 24, Milord. 2012, 13 SCC, page 568.
2000?
2012, 13 SCC, page 568.
Yes.
Milord, this is Civil Procedure Code.
Yes.
Head note may kindly be.
Yes.
Order 21, Rule 84, 85, 89. Auction sale of real property in a partition suit. May kindly make a note.
Yes.
Payment of bid amount by demand draft sale held not vitiated, not depositing bid amount when did amount running in cross of rupees, etc., etc. Then paragraph 14 to 27 may kindly be seen.
Paragraph number?
14 to 27.
Go to my page number.
Page number, my lord. Page 31.
Yes. Yes.
Paragraph 14, we are full agreement with the order passed by the executing court as well as the High Court that auction purchaser deposited 25% on 8/1/2010. Auction is for such a large amount running a crores of rupees. Nobody can expect auction purchaser to pay the amount in cash on the fall of hammer. So far as the instant case is concerned, fact would reveal the auction purchaser paid so and so amount, but the draft on so and so, bid amount was also so and so. Auction purchaser complied with the in view of provision of Order 21 Rule 85. Ultimately, my lord, this honorable the Supreme Court said it vitiates the sale that your lordships will get at, my lord, may kindly go to page 578, my lord.
Yes.
My lord, in which there is a nice Order 21 Rule 92 is extracted.
Yes.
Then, my lord, the Constitution bench held that, could your lordships, my lord? Order 21 Rule provides that deposit made within 30 days from the date of sale and application is filed would no discretion but to set aside the sale. Then that does not mean the deposit is made after 30 days. Court could entertain the application if the deposit made beyond 30 days, etc. Then Law Commission report is also suggested. What is the suggestion of the Law Commission report? Then ultimately the Supreme Court said, paragraph 22 and 23, sale is set aside. View taken by the High Court and the executing court found to be correct. It is said proceedings arising out of a partition suit. That's what in my application for amendment, I took a contention that provisions under the Partition Act is only an enabling provision. Auction has to be regulated only under CPC under Order 21 Rule of 5. This is.
This will dictate the judgment.
One point I would like to make it clarify as a replay, my learned friend refers to the compromise application at page 24, Annexure B.
Para 8 and 9.
1 minute. That was dated on 11/1/2008. The compromise decree was passed on 24th. That was a decree was passed later on.
Yes.
No deposit and no auction have taken place 2011. Your Lordship may kindly see the property locating in a very prime area at Bangalore city. 3 years, there was no development. Despite parties have agreed to settle the matter by way of auctioning the property and enjoy with the sale proceeds, 3 years, no developments have taken place. Normally, after 3 years, normally, my lord, there's an escalation in the market value of the property. Keeping in view of these things only, Lordship Miller, who heard the matter at the earlier occasion, suggested the other side to see equity to be maintained in the light of this gap of the term between the auction sale and the compromise. Therefore, look at and negotiate. That was the suggestion given to them. My lord, what I submit is, if everything is normally took place, this would not have been reached to your lordships. But parties have not acted in terms of the compromise. Deposit could have been made when the B schedule property agreed to be sold in public auction. No explanation is forthcoming from 2008 to 2011 why the auction was not in progress. Well, the ultimate argument would be on looking into the precedents of the apex court and authority on the judgment as held by the apex court is concerned, irrespective of the fact of issuance or sale certificate or any other development. Basically, there is no sale because the court holds it's a nullity in the eye of law. There is no sale. When there is no sale, if any subsequent proceedings, auction or sale certificate, kata, mutation, would have no consequences at all. That's what my submission. I think my presence may be dispensed in the afternoon. If in inconvenience, my lord, I may not come.
Not required.
Right.
Submission. Certain citations have been given along with my objection statement.
What you have cited now?
Already.
Another judgment. That also will record in the afternoon.
That's the
Yes.
point.
Call the next list.
17. Arun Govind Raj, cell number 17.
Petitioners.
Yes.
Petition by the mother. No, challenge lies in a very limited corpus. The father had filed an application before the.
What is this for in CP number?
Caveat filed.
Oh.
Caveat. I will pay record.
Yep. Yes. So CP means caveat petition.
Caveat petition. But the father filed an application for injunction, my lord, against the mother. She should not remove the children. There are twin children, not 3 years old. Should not remove them from the jurisdiction of the court. The mother gave a written undertaking before the court that I will not remove them permanently. But whenever I travel outside, if it's going to affect the father's visitation, I will inform him. The father also files written arguments to the same effect. If she is traveling outside affecting my visitation, let her inform me. The family court goes one step ahead and says, every time I travel out of Bangalore with my children, I have to inform the court also. That is all. That's the only grievance that I have with the order passed.
Your lordship may kindly take the written arguments which they have filed at page number 66.
No, before going to the written arguments, no, as far as it is not affecting the visitation, what is the difference?
Well, without affecting my visitation rights, because
that would be
If it
clarified.
affects the visitation, then I have to inform. Is what even he wants, not before it is his own written argument.
Let's see the order. Let's
Yes.
see the order.
No, the order is at page 73. The operative portion, 74 would be the
Yes.
74, if not would pen it. But the first paragraph. The respondent in the written argument submits that she has no intention to remove the children out of the jurisdiction of this court. In case if she wishes to travel outside Bangalore for the purpose of recreation or to visit her relatives, she will duly inform the petitioner about the date of travel and undertakes to compensate the petitioner by providing alternate visitation rights during weekends. Admittedly, the children so-and-so are under the care and custody of the mother respondent. In view of the undertaking given by the respondent in the written arguments, proceed to pass the following. IA number 2 is hereby allowed. Respondent is hereby restrained from removing the children from the jurisdiction of this court without the leave of this court. The respondent shall inform the court as well as the petitioner before taking the children outside jurisdiction of this court and shall furnish the details particulars.
What is
This
the, how you are exercising the visitation is, what's the duration?
My lord, only
2 hours
2 hours every Saturday.
2?
2 hours
No,
every
2
Saturday.
hours in every
Yes,
Saturday. No, for any reason,
Yes,
if on a Saturday, if she takes the children out of Bangalore, she should compensate you on another
Lord,
day.
one Saturday I can understand, my lord, but it should not be for months together. My lord, that is the main issue, my lord.
No, it's not that. She won't be, no, the children are going to the school.
Yes, my lord.
No, how could she take them away
Well,
just
that is
like
the
that?
reason, my lord.
No, if it is, no, what happens is, if this Saturday it is not possible, she should compensate it in the next, within Monday to Friday.
Yes, ma'am.
So it won't be like every Saturday it
Madam,
will
that's
happen
what-
and after 10
Madam,
days
one
you do
Saturday I
it.
can understand, madam, let there be a restriction saying that one Saturday it's okay, madam.
Not
But
one Saturday. What this court will observe is.
continuously, there should not
No,
be.
no, no. No, for example, on one Saturday, it is not happening.
Yes, ma'am.
You should get your visitation, that is for 2 hours, sir.
Yes,
It
ma'am.
could happen on the weekdays also.
Yes, madam.
Is it not possible for you?
Well, it's possible, my lord.
Ah.
My submission to her, my lord, because the children are only 3 years. My lord, only 2 hours that has been visitation rights has been given to the father.
Hmm.
My lord, if continuously if shakes or takes away the child for a
No,
week,
your thing is once in a week.
Yes,
It should
madam.
be done every week once.
every week once.
So if it is a Saturday or a Friday, how does it matter?
Well, that's what, my lord.
No, provided if you tell the court that except on a Saturday, no other day
No,
is
no, no.
not.
That is okay
No,
with
what,
me.
no, what the court will observe is, every week you should have your visitation. If some days, if on any week, if it has not happened, that 1 day or 2 days, whatever should be compensated immediately the next week.
Immediately the next week, madam,
Ah.
that's.
It should be fair for him.
Yes, no, I have no intention of leaving Bangalore and going
No,
outside.
no, even
completely.
if you go,
Yes.
like you should be, immediately should be compensated.
As
not
soon as
like
they come back,
whenever
I'll
it's
compensate.
convenient to.
Well, that's what, madam, come back means, my lord, the bondage that created, my lord, within, for a period of long
No,
time.
every week you will have.
Yes, madam,
No,
that's what.
at maximum, they may go on a week.
Maximum 2 weeks, maximum, not beyond that. Maximum, because my
That
parents,
would not happen every week.
not every,
Well,
both,
that is the-
both are lawyers working in Bangalore.
Hmm.
Uh,
So, no, one thing is there, if whenever you're leaving out of the car, out of
I will
the
inform, of course. I
the
will.
itinerary and all, he should know
Absolutely.
where are you going? So that
Absolutely.
you'll understand whether it is
Madam,
genuine or
let them
not.
inform. My submission, madam, continuously for a period of 2 weeks, more than 2 weeks, the visitation right should not be cancelled.
More than 2 weeks, yes.
Hmm.
No, not,
That's all.
no, if I go, I will not go for more than 2 weeks. Not if I'm going for more than 2 weeks, I will inform him, take his car, we will discuss amongst ourselves, then I will go.
No, you can sort it out. There can't be any hard and fast rule like that.
That restriction, with that restriction, it means.
Please come. Agreed with the orders passed in I number 2 in MC number 2341 of 2022, dated 12/6/2024. The mother is before this court. The application is, who has filed I number 2?
Father,
miss.
respondent.
2 is filed by the father seeking an order of injunction restraining the wife from removing the children out of the jurisdiction of the court. Then to that, an objections were filed by the wife stating that she has no intention to remove the children out of jurisdiction of the court. In case if she wishes to travel outside Bangalore for the purpose of recreation or to visit her relatives, she will duly inform the husband about the date of travel and undertakes to compensate the petitioner by providing alternative visitation rights during weekends. The court, by order impugned, had allowed the IA restraining the mother from removing the children from the jurisdiction of the court without the leave of the court. It is also observed that the wife shall inform the court as well as the husband before taking the children outside jurisdiction of the court, and shall furnish the detailed particulars of travel and shall compensate the petitioner by providing alternative visitation rights to the children. When a counsel appearing for the petitioner wife submits that the order that is passed by the court, wherein every time when on every occasion she's traveling out of the Bangalore has to be informed to the court, is something which is practically very difficult. He submits that she has filed and given an undertaking before the court that she has no intention to remove the children out of the jurisdiction. And if she wished to travel outside Bangalore, she will duly inform the husband and also compensate the visitation right. And when that is the case, the court below ought not to have passed such an order wherein every time it is mandated that she should take the permission, she should inform the same to the court. Next paragraph. Then a counsel appearing for the respondent husband submits that if as a practice every time if the children are taken out of Bangalore and if that that gap makes a lot of difference for the father in developing the bond with the children, there should be a there should be a condition that she cannot be out of Bangalore beyond 2 weeks. Next, considering the submissions of, on the parties on either side, there is a material on record. The children, both the children are in the care and custody of the mother. And mother has given an undertaking before the court that she has no intention to take the children out of the jurisdiction of the court. However, whenever she is going, she'll inform the same and she will also compensate. This court finds that the said objection or the said undertaking given by the wife is definitely, which will also safeguard the interest of the father in meeting the children. Hence, this writ petition is disposed of, directing the wife not to go out of Bangalore beyond 2 weeks.
Such a restraint is not there in the family court order and they've accepted it.
Now, what will happen? Then how will he exercise?
Yes.
My intent is not to deny, Lord, in case, my Lord, now, my Lord, her brother is now living in the US. In fact, she was supposed to go for his graduation. She's not gone because of the order of this court. She did not, I asked her not. My Lord, to the largest possible extent, my Lord, we will not, both are working professionals in Bangalore, practicing. So, my Lord, such a restraint, my Lord, we will inform and we will, my Lord, make all endeavors to make sure that it's not more than 2 weeks. He does not miss a visitation for more than 2 weeks. All endeavor will be made.
To the extent possible, the mother should not take the children out of Bangalore beyond 2 weeks. If such a situation arises, in advance, the same shall be informed to the husband.
Obliged.
And that exception can't be
It will not
on
be
a regular basis. Next, whenever only on a Saturday it is given.
Only on Saturday, I'm filing it.
How can it be, what is the Saturday towards
To-
visitation?
In that 2 hours also, my lord, the mother.
The reason is, from the time the children were 3 weeks old, the father has not had any interaction. The court said, we'll start with this and thereafter we will see.
As undertaken by the mother, the visitation should be, whenever she is out of Bangalore, that should be compensated immediately after coming back. And mother should see that the visitation happens on a regular basis. It should be the responsibility of the mother.
Like,
18, Banu Prakash, BG, 18.
Petitioner in the matter, my lords. Subsequent to the orders passed by my lords on 18, application has been filed for seeking a modification at the hands of this honorable court for 2 reasons, lords. Initially, at the time in the month of March, when my lords had passed an order directing the petitioner to keep herself and the baby present in India and for the baby to continue the education in India. Yes, my lords.
The girl and the mother should be present before the court.
That's
Where
the
are
reason
they?
I'm making this submission. Not she is in Dubai. My lords had indicated that by July she should be here. July 31st, before 31st, I'll ensure that the.
No, what is this conduct of the petitioner? Now, having obtained an order with the
Yes.
permission of the court,
Yes,
when you left the country, when the date is
Lord
not
said-
indicated,
18th, my lords had indicated.
then
But the understanding was this, my lords,
no,
saying
whose
that
understanding?
the client's understanding was
How
this,
can
that.
she understand when the order says, please look at it?
No, no.
Pose this matter on, yes. When was the matter directed to be?
18th of July, my lords.
And then,
My
what
lords,
does it mean?
The end of July is what the understanding was.
Not understanding, please refer to the order, one paragraph in the order.
I may
where
read
the
that.
court said that you come after end of July.
May I read that, my lords?
Yes.
6
please.
6 lines from the bottom, Roman 3,
Page.
my lords.
Which page?
The order, just before the order ends, dated
Yes.
20th of March, my lords. The Roman 1 to 3.
Then this is a fit case where the court should take the extreme.
My lords,
step
I'm
for
only
issuing
explaining
the
my
warrants.
conduct as to no intention of violating this court's order in any manner, my lords. Let the,
When you want to leave the country, you can fight tooth and nail.
please, my lords.
And you can leave the
It's not that
country.
we are not coming back. The understanding was, this is what I'm trying to emphasize before this honorable court.
Yes.
It says, my lords, once the child is brought back to India in the month of July.
Why the court has not, it should not be after 18.
I understand, my lords. I
7,
understand.
20,
The
24.
understanding, my lords, I'm only making a submission before my lords to say.
No, it is not understanding, Mr. Counsel, because court having passed an order of 21 pages, don't the court know what are
Of
the
course,
things
Milord,
that
I'm not
transpired on
disputing on
day?
that.
You were not
Client-
there on that day.
The
when
client,
this
of
order
course, I was not even
passed.
representing the client as on that day.
And the court firmly believes that this is an intention on the part of the mother. And had it been her, when the matter is coming on 18/7/2024,
Please, Milord.
when she very much knows it,
Please.
before this date, she would have come up with an application.
Milord, application
Filed an application, kindly see that application, my lord. She
When was
says,
it
"I will-"
filed?
yesterday, Saturday, Milord.
How can it be filed on a Saturday?
Now, my lord.
When the court has specifically said she should be here.
Milord, she could
Kindly
not
see,
come
Milord.
before this honorable court is the submission I'm making, Milord.
Please see, my lords, the application, strangely they say, I will never bring the child, that's what it is.
She will never?
Kindly see the page 3 of the application,
Let us say, please.
last 4 lines.
Sina counsel is making this.
The application is, the petitioner further prays that this honorable court be pleased to permit the petitioner to continue the education of the child, Miss Dash, to continue her education in Dubai. And the custody of the child will be given for 15 days to the respondent in Dubai. All that she
That is
is
the reason,
finding fault
us
with the
in a
court's
finish
order,
part.
number 1.
the
Number
reason
2
why
is
that,
this.
the reason why that was made was,
There we are.
I'm told, Milord, on instruction submitting, that a document is produced before this court by the respondent that he is a resident of Dubai, a visa which would indicate that his residency ends in the month of
We will not
2025.
hear any of it.
Please, Milord.
She should have the respect to the court
I
order.
understand, Milord.
And the court will not permit any litigant
Please.
to abuse the process
I understand.
and take advantage of the order when
Please.
it is convenient to them.
No, Milord.
And to
please.
say that, and how dare she is to file such an affidavit before the court when that is the order of the court.
Milord, she is only making an application to seek in the modification at the hands of this honorable court because of the fact
First
that
let
she
her
is.
come.
Please.
First let her come before the court.
Next
When
week.
is she appearing?
Mm,
And I think this is a case where I think that the order, that some steps to be taken for her.
Milord, my
To
submission
issuing an
before,
order to the authorities.
I will advise her to keep herself before the court along with the child. Next week sometime, my lords may have it.
To leave the country, she doesn't require any advice. To come to country, she requires. I know that. Even that day when this order, I was very much reluctant to pass this order.
Please, Milord.
Only to accommodate and to see that
The child
she-
continues her education.
not the child continues. That mother, like she wants to have her own, her right to life and her whatever prospects she has.
Please, Milord.
Nothing what she has placed on record is, the court has its own doubts on what all the documents.
Produce
that
a
are
document
produced.
now to indicate that she is
No, that
employed.
is there. She says she works in a marketing and when it comes to the, she'll get an job in
No,
an oil
subsequently,
refinery.
She has got a job, 2 months salary is credited to
No,
account.
that is true. In an oil refinery,
Now
she will
has
get a job.
produced- Now she has.
I will keep her
produced
present.
Very strange.
I will keep her
Definitely,
present.
definitely, your client should know that the court will not take things so lightly. And when is she going to be present?
Next week, Milord, because she is employed right now.
Whatever it is, court is not concerned.
I'm just
Yes.
making a submission.
Please let her propose this matter on Monday, 29. By
Milord,
that time,
could it be had on Wednesday, Milord, 31st?
no, already she had enough. Monday on 29. By that time, if the parties are not present before that, court will take the coercive steps. Yes.
Please.
Then
May I make a submission? Kindly, your lordships.
You know that there can't be a mention at this time?
No, my lords, I am not seeking time, my lords. In fact,
Time, what is that you're seeking?
my lords, the respondents have sought time in the morning, my lords, without
case?
informing us.
Which case?
Serial number 26, my lords, without informing us. In fact, we have urgency in this matter, my lords.
Inform them. We will take take the matter. Inform them.
Please, my
If they are
lords.
there, or inform them.
Please, my lords, oblige me.
On the cause list, please mention that without mentioning to the other side, no mentioning, no, nothing, nobody should mention before this court. That is, it requires, like a basic courtesy that others should, that you should mention, inform to the other side and then mention. Unfortunately, that is also not followed.
Yeah. ಮೇಡಮ್ ಇಲ್ಲಂದ್ರೆ ಸೈನ್ ಆಗ್ಬಿಡು. ಸೈನ್ ಆಯ್ತಾ? ಆಲ್ರೆಡಿ ಸೈನ್ಡ್. ಅದರ್ ಸೈಡ್ ಯಾರಪ್ಪ ರೆಸ್ಪಾಂಡೆಂಟ್ಸು?
26 ಮೇಡಮ್.
ಆಲ್ರೆಡಿ ಸೈನ್ ಆಗಿದೆ ಅದು. ರಾಜೇಶ್ ಗೌಡ.
ಏನ್ ಬರ್ಬೇಕು? ಆ ಕಡೆಯಿಂದ ಹೋಗೇ ಇಲ್ಲ. ಮೇಕಿಂಗ್ ಬೆಳಗ್ಗೆ ಕೊಟ್ಟಿದ್ದೆ.
Also, line 86
Madam.
4000 400 432 400 432.
ಅಲ್ಲ ನಾನು ಇದು ಮಾಡಿದ್ದೀನಿ. ನಾನು ಡೈಲ್ ಮಾಡ್ಕೊಂಬಿಡಿ ಮೇಡಮ್ ಮಿಸ್ಟೇಕ್ ತಿರುಗಿ ಬರುತ್ತೆ ನೀವು ಆಪೋಸಿಟ್ ಮೊನ್ನೆ ಮೆಮೊ ಮಾಡಿ ಇಲ್ಲಿ
ಅದೇ ಕಂಟಿನ್ಯೂ ನಾಳೆ
ಇದು at the request of blood counsel for the petitioner ಇದೆ. ನಿಮ್ಮವರೇ ಏನಾದ್ರು ರಿಕ್ವೆಸ್ಟ್ ಮಾಡಿದಾರ ನೋಡಿ. Petitioner ಅಂತ ಆಗಿದೆ ಅದು. Petitioner ಅಂತ ಇದೆ at the request of blood counsel for the petitioner. Petitioner ಅಂತ ಆಗಿದೆ ಮೇಡಮ್. ರೆಸ್ಪಾಂಡೆಂಟ್ ಅವ್ರು ಯಾರೋ ಲೇಡಿ ಅಡ್ವೊಕೇಟ್ she has come and confirmed and gone. Petitioner ಅಂತ ಆಗಿದೆ 26. At the request of learned counsel for the petitioner ಅಂತ ಆಗಿದೆ. ಇವ್ರು petitioner ಗೆನೆ.
27 ಆಗಿದೆ.
ಹೌದು.
27
Madam, it is at the request of learned counsel for the petition. ಅವ್ರಿಗೆ ಹೇಳಿ.
ಯಾವ್ದು ಹೇಳಿ ನಮ್ದ 27.
So you filed a writ petition. No, let this writ petition go, you pursue it there. That will also go. IA number 1024 is filed to condone the delay of 1 to 44 days in filing the recalling application. This court by order dated 23/8/2019 had granted time to comply with the office objections. As the same was not complied with, the writ petition is dismissed. The present revision is filed, agreed by an order dated. Where is the order? On IA number 1 dated 23rd January 2018, whereby the court below dismissed the same at cost of rupees 3,000, out of which 2,000 shall go to the District Legal Services Authority and rupees 1,000 shall go to the plaintiff. The application that is filed by the petitioner is that she wants to file the written statement, since she has not filed for the reason that the summons issued by the court did not have served on her or received by her. The suit is of the year 1997. The present application came to be filed in the year 2018. Now, when it came up before this court, even before this court also, the petitioner was not diligent in pursuing the matter. Now, when an order is passed on 23/8/2019 with a delay of 1,244 days, the present petition is filed for recalling the application. A courts can never come to the rescue of a litigant who is not vigilantly pursuing the litigation. Learned counsel submits that it's a suit for partition, and the suit is still pending for the cross of DW, cause of DW2. The reasons that are stated in the affidavit are also not satisfactory. However, considering the fact that this is a suit for partition, and the petitioner being the defendant in the suit, this delay of 1 to 44 days in filing the application is condoned on the condition that the petitioner shall pay an amount of rupees 20,000 to the Legal Services Authority. The petitioner shall serve the notice on the counsel appearing for the respondents before the trial court and shall file a memo to that effect by 12th of August. If the memo is not filed, the writ petition stands dismissed without further reference to the court. If the memo is filed, post this matter on 21st. Yes. Is disposed of. Is recalled. Restored.
Number 12.
Petitioner's counsel. One, my lord.
Morning, why is it adjourned?
It is for.
Why?
My lord, you pass out the matter because it's a very old matter, my lord, in the year.
No. Morning also he was not there.
The morning also is not there.
How many times a passover you can see?
My lord, very small question, my lord. This court, my lord, in the MFA, receiver appointed, my lord. I filed the application before the trial court. He's serving the.
No. If there is a representation time and again, we have to understand that it's a small matter.
I appointed the receiver, my lord. I filed the application.
I'll call the next matter. By the time he comes, yeah, it's fine. If he doesn't come, also we'll dispose of the matter. Huh? What is that?
Tomorrow, he's seeking that
No,
tomorrow.
he might not have objection. Court has objection. It has to be today. Ask him to come. Yes. No, which matter is, what we'll do is, no, this, as far as this preliminary hearing, the group are concerned, we'll complete that and then I'll dictate the judgment because it will take a lot of time.
Preliminary hearing B group, CL number 19, Abhishek, 19. Raghavendra V for respondent.
Which code? You have called 19? Yes, yes. Oh. Injunction.
They're asking for a declaration mandate to maintain correct which. But insofar as measuring this property is concerned, I don't have a question. And even the trial court finding is that even for declaration mandate to maintain subject matter issue that should be inspected. Here, what is regarding the 3 acres of land.
You're the defendant.
And the there is no law. He has sought for measuring 3 acres of land. Then the subject matter is only 5,400 square feet. And this state lead is also for only 5,400 square feet. Regarding measuring this property, you don't have any objection.
Yes.
Please, my lord. The entire land of 3 acres 6 guntas belongs to one Amina B. Malad, that is, there is no dispute. 12 guntas of land she has gifted to her daughter. 2 acres of land has been gifted to the son, Malad. Now I purchased this out of the 12
First of all, as far as your property, there is an encroachment or not is the question. So why should the entire 3 acres be?
The version of the other side is this, my lord. I am trying to put claim on their property on the guise of this sale deed which I have purchased from their ancestor. Now they say that.
Who are the defendants in the suit?
No, they are the subsequent purchaser. They keep on.
They purchased the entire 3 acres.
No, 2 acres of land, which was gifted to the son. In the gift deed, it is clearly mentioned in the boundary, my lord, to one side, western, eastern side, my 12 guntas is situated. Out of the 12 guntas, I have purchased 5 guntas. Now, when it was a vacant land, in my absence, there are several structures were put down. The entire scheduled property, Schedule A property, 60 by 90 measurement. B, C, D are the encroached portions which I have given. Now, they said that there is no such property at all. And I am laying my hands onto their property, which is the 2 acres of land. No, my lord, it is imperative, my lord, after conclusion of evidence, based on the documents produced by me, that is my sale deed and the original gift deed, and their sale deeds, it is imperative, and the trial court has opened.
What is your extent?
Pardon?
How much is your extent?
60 feet into 90 feet. No, they say that there is no such property at all. And what is the construction is done, it is on their property. So now I am trying to lay hands on their property. It is because of these conflicting versions. And by perusing the documents produced by both the sides, trial court has opened that it is a fit case to appoint a commissioner to investigate the property, to identify where my property is situated and where the property of defendant is situated.
No, when that's your case, it has to be done. When you say that there is no property at all the property, whatever the structures are raised, belongs to you, then the court has to necessarily see, no, there is no dispute about the fact that he has purchased a property by way of a sale deed. You have purchased a property by way of a sale deed. Both the sale deeds are there. So what is your property? What is the remaining property? It will be clear. No, what is the prejudice to you? That you tell the court. Yes.
And he wants to appoint the surveyor for measuring municipal property where there are already structures which are come up in the entire property. It is not practical. And secondly, it cannot be allowed because it goes
No, whatever is the evidence that is collected as far as the suit issue is concerned, you be restricted to that.
Therefore, there is no finding that there is imperative to measure the entire property.
Let us see what are the application, what is your respective stance? Well, let us see their affidavit.
Annexure E, page 56 to the read.
The prayers are for present. For the reasons shown to the accompanying affidavit, the agency about this must be placed. The Dismissals will be appointed Taluk surveyor, Mangarpet Taluk for local investigation of off-specific property and its adjacent property. That is the entire land in survey number 145/1.
That is 3 acres.
3 acres. Of Mangarpet village, Kasparapalli, Mangarpet Taluk. Based on the measurements and boundaries mentioned
In that 2 acres belongs to you.
2 acres. It is only the part of their property. You lay the entire property by the D, C and D are part of the schedule A property. Only those sites belong to me.
How much is the extent?
It is, it falls within the does not exceed. I'm not claiming title over 2 acres. Right, predecessor may have got 2 acres, but I am claiming title for what cost?
What he is claiming, you are also claiming title to that property.
Yes, your boundaries can be seen, and if there is any equipment, the commissioner can make note of that, and accordingly, my directions are already there before the court.
Let us see what is your stand? Where is your written statement? You are which defendant? You are which defendant? 1 to 4, on page 39. Yes. Hmm? Hmm. Yes.
Declaring the plaintiff the absolute owner of real property, this B, C, and D properties put together, and direct the defendants to hand over and deliver vacant possession of real property to the plaintiff by removing the illegal structures, consequently for permanent injunction. So the description given for scheduled A property is not east to west 60 feet, north to south 90 feet. And he has identified property by a municipal number. There is some falling within municipal.
Then please come to the written statement.
Now, these three are the properties which he is saying that it is entered and it belongs to the defendant.
What is your response to that?
Pen number 1 is the owner of the page 44.
We'll say let the suit schedule property be, please come. Agreed with the order passed in. I number 14. Invoice number 52 of 2013, dated 1/2/2021. The defendant is before this court. The respondent herein has filed a suit for declaration and for permanent and for mandatory injunction in respect of plaint A and B scheduled properties. A and B scheduled properties. In that, he has filed I number 14 to appoint the court commissioner. In that, he has filed I number 14 to appoint Taluk Surveyor, Bangarpet Taluk, for local investigation of suit scheduled property and its adjacent property, that is entire land in survey number 145/1 of Bangarpet Village, Kasaba Hobli, Bangarpet Taluk, on the measurements and boundaries mentioned in exhibits D1, P1, D2, P2, and D68, and other subsequent title deeds, and to submit the report. The defendants have not filed their objections to the said IA. You are fine? Where is that? Let's see, page number 60. They have filed their objections, wherein it is stated that the plain scheduled property carries municipal Khata number, unequivocally demonstrate the property is within the municipal town limits and is no more agriculture revenue land, and the prayer for appointment of surveyor is untenable, and the application is liable to be dismissed. And there is no necessity to appoint a commissioner. The discretionary power of the court to appoint commissioner would arise after completion of evidence on both sides. Then the evidence is not complete.
It is completed at the time of arguments, application is filed, because there are several sale deeds, my lord, several sale deeds.
The application is premature. Looking at from the well-settled proposition of law. Now please come to the order. You have the docket proceedings to show that by that time the evidence is not complete. It was considered. The court had considered the respective stance of both the parties. that the defendants have set up their title in respect of the portion of the suit schedule property. And as of now, the evidence of both sides has been completed. In the evidence, the parties have reiterated the amendments made in their respective pleadings. Moreover, both the parties have produced counter title deeds. It can be ascertained which of the title deed is valid and legal, but in order to ascertain whether or not the said portions of defendant numbers 1, 5, 3, and 6 falls or overlaps, coincides with the suit schedule property, it is necessary to engage a commission to inspect the suit schedule property and to measure the same. And accordingly, the court had ordered the application, the Chaya number 14, and Taluk surveyor is hereby appointed as court commissioner, and he was directed to carry out all the necessary instructions that are instructed by both the parties. The plaintiff is further directed to do follow-ups with court commissioner to execute the same at the earliest time. Learned counsel appearing for the petitioner submits that the suit A and B schedule properties.
My lord, A is the entire property, my lord. The encroached portions are the B, C, D, and other.
According to the plaintiff, suit B, C, and D schedule properties are encroached by the defendants. They have purchased the property by sale deed stated 28/7/1966.
No, my lord, it's a gift deed, my lord. Subsequently, there was a sale deed, my lord. They're all purchased, subsequent purchasers.
That's what, when is
Later,
your
of late
purchase?
purchases.
No, court was the transactions, it is referring to 28/7/1966, 3919.
My sale
That's
deed.
what is that? 28/7/96 also.
It's a gift deed, my lord. It's a gift deed.
That's what transactions are. No, the court has, even as per your prayer also, you wanted the court to look into those and accordingly. What did you? Both the properties, both the plaintiff and the defendants claims that they purchased the properties by way of sale deeds. Learned counsel submits that now by virtue of this order, as per IA number 14, the entire survey number is directed to be surveyed, and which is not required in the facts and circumstances of the case. Learned counsel submits that as far as the plain schedule property is concerned, if the same is surveyed, shall record that you have no objection. If the same is surveyed, he has no objection. Next paragraph. Learned counsel appearing for the respondent, plaintiff submits that as the entire survey number consists of 3 acres and some of 2 acres is given to the son by way of a gift deed, and the son had sold away the same in favor of several
defendants,
in favor of the several parties, and they are the defendants before the court. That's what. So several and the subsequent purchasers are the defendants in the suit. As such, it is very much necessary that the whole 3 acres of land, the whole extent in the survey number 145/1 needs to be surveyed. Next, and the court below had rightly ordered the petition. The writ petition is liable to be dismissed. Having heard the learned counsels on either side, peruse entire material on record. The whole dispute is with regard to the plaintiff, a schedule property, and the B, C, D are the encroached areas, encroached land of the plaintiff by the defendants. Defendants are claiming right to the property by way of certain sale deeds. Now, in the in a suit for declaration and for mandatory injunction, if after the evidence is completed, now the commissioner is sought to be appointed. In that case, considering the sale deed of the defendants and the sale deed of the plaintiff, the surveyor has to measure the land. And the measuring the entire 145/1 survey number is not necessary. Hence, in the
Sorry for the interruption. But my humble submission is not. In the application, I have clearly narrated the sale deeds. my lord, exhibit D1, P1, T2, P2 and C68, my lord. Originally, there were some other boundaries, my lord. Now, by changing time, my lord, changing the hands, they have given different descriptions which should match my property. That is what they have done. Now, my lord, survey of this property is very much essential. Though it's a municipal number, my lord, originally it is a survey number. So the taluka surveyor can effectively survey the property. Now, it is very easy for him to identify the land where my 5 guntas is situated, where the property came by the other side is situated. If that is not done, my lord, then it would be difficult for the court to, my lord, give a finding.
So you are the subsequent purchaser here, say.
No, I am not a subsequent, I am the original purchaser.
No, you are the plaintiff. Oh. Let it go on, basing on the plaintiff's document and the defendant's
Because
document.
of these conflicting versions, my lord, it is very much essential, but because of the conflict, if they have admitted my time, my lord, that I have purchased the property, I am in possession, that is a different aspect.
No, court
No,
will-
they say that.
No, the commissioner will tell the court what is the property as per his boundaries, because he is, the plaintiff is, you are the
For that,
person.
he has to look, he sold it also.
No, you have purchased the property, your document is earliest one.
Yes, madam, yes.
Then the court would look at, the surveyor will, the commission will do that. And their document is much.
No, I am not claiming their property. What I am asking is, my lord, my humble submission is this, my lord, let the survey be done to their lands. They have given some description.
That's what their land also, whatever is the, that's what I said, your land, your sale deed, and basing on your sale deed, the placing on the plaintiff's sale deed and the defendant's sale deed, sir. Basing on that, there shall be a survey.
Please.
Huh? Yours only. Yes, as per the sale deeds of the plaintiff and the defendant, the survey should be conducted accordingly. Let petition is disposed of. Yes,
Number
next.
20, Malappa, Na,
Yes.
B. Ramesh. With the respondent, my lord.
Yes.
Come on, NOC, my lord. My lord, this petition is infructuous, my lord. They've already filed the objections on 21/6/22.
What has become?
It's infructuous, my lord.
What is the impugned order? What is the impugned order?
Annexure,
An order, no, a petition is filed to review the order on IA number 4. What is IA number 4?
my lord.
When was that order passed? Original order is passed when? 25/1/2021. Then when did you file the review? What is the review in that? On what ground?
My lord, on 21/6/22, they filed their objections, my lord, for the main petition.
Let's see, whatever she wants to spend tomorrow. At the request of land council for the petitioner. Yes.
Number 21. PC Vinita for petitioner. Here for petitioner. Virupakshaya. That protects, they have withdrawn. And now, wherein now the child is studying in the residential school. And in fact, the divorce petition is pending in the family. Wherein the mother, by comes to a mediation, she agrees and takes a deed. And the court, it is the mediation agreement is gone before the court, so it's a secular and where in the first round when the matter is called in the fact, she takes a deed and the second round she never heard. And then she goes and files an execution after taking impression the deed. That agreement and that way she has done her, she filed an execution petition that has been challenged before the reputation and there was a stay order also. And in fact, here the improved order is only with regard to the cancellation of the reputation. Now.
Where is that petition of which year?
That reputation of the year 20.
Give the number, we'll have both. Post both the writ petitions on Wednesday. Post along with so and so. Give the number, write it on the paper and give. Yes.
Number 22. Harish N.R. for petitioner.
I appear for
Jeevan
the
Kumar
respondent.
V.S.
Who appears for the petitioner?
Mr. Harish. Last occasion, before
Last occasion also no
Because
representation.
he was there. Before last occasion, the matter was adjourned on his request that he would get prepared. Last
No
occasion,
representation for the petitioner, counsel for the respondent is present, post for dismissal on Wednesday.
Till number
Yes.
23. 23. Suresh K. for petitioner. Vicky.
What is that? Take that. Yes. What is the suit for? You are the plaintiff? When did you purchase the property? 1972. And what is your case? What the defendant is doing? And how he asserts title of the property? You purchase the property from whom? A joint family property is purchased by you.
After that, they entered into a partition, the family members. At the time of entering the partition, they might shoot his property or included in their partition.
And it fell to his share. What is IA now?
There are two ideas.
Not to urinate, not to interfere. And then what did the appellate court do? Let's come, please come to the trial court order. When was your sale? 1972. When was the partition? 2-1? Who had sold this property to you? You are appearing for?
I'm opening for the subsequent purchases.
Defendant number 4.
For three, yes, 3 and 4.
So both of you are purchasers of the joint family, that property. When was your sale date?
My sale did my lots,
22/9/2005.
please.
Who is his vendor? No. Your vendor is?
Not my grandfather.
Hmm.
Defendant number 1 and 2's, original defendant number 1 and 2's great grandfather
Hmm.
had sold the property.
So D1 and D2 sold in favor of D3.
D3 in.
D3 sold in
No,
turn.
D3 in
gift
favor
deed.
is my, D3 is my father, D3 is father and D4 is a son.
Hmm.
So he gifted the property to D4.
Hmm. And what is evidence to show that you are in possession of the property? Photographs, no other documents. There would be revenue extracts will be there.
All the revenue extract stands in the, as present, my lords, all the revenue record stands in the name of defendant number 4.
No. There, you have purchased the property. Invitation should have been taken place till 2005. Suit is filed in which year? What are you doing from 2005 to 2020? As far as the not to alienate is concerned, it's a different aspect. No, not to interfere. For that, you have to say that you have been in possession of the property. You know, why would they appear?
Yeah.
They would not appear. No, at least this suit is filed in 2020. So some document should be there from 2022 till 2005 to 2020, showing that you are in possession of the property. Oh, that's all correct. As far as not to alienate is concerned, will confirm that order. But what about this? No, for not to interfere. Huh? No, that's what whoever is the owner of the property will do it. No third party will do that. And that too, you can't say that right from 2005 until 2020, we are just sleeping over the matter. So if that's the only thing, then what we'll do is, like, as far as not to alienate is concerned, that will. Where is your property? If If the court gives such a finding that's your property, then why not injunction? For giving a finding that with regard to your possession and all, what is the evidence that is let in before the court? That all will be decided eventually in the trial, not now. At this stage, prima facie, what is that to show that we can understand, like 2005, the husband expired and some suit is filed in 7 or 8, at least we can understand. The suit is filed in the year 2020. It's almost 15 years, long years. So that we will confirm as far as not to alienate is concerned, but injunction will set aside that order. Status quo is the most dangerous order of all. That is the whole difficulty. What is is not clear before the court now. If you make it, you tell the court that this is how I have been in possession of the property, then we will consider. That is important. Now, basing on your sale deed and all, as far as not to alienate any, you have come before the court seeking declaration, we'll ask them to maintain not to alienate the property, so that no further rights
So
are
far as
created.
after my client's instruction is that, my lords, he does not intend to alienate, therefore,
That
that order may kindly be passed in respect of non-alienation.
Please, from the order, one line you show the court that it speaks about your possession. Then we will pass orders. Or else, short passover. Look at it and tell the court. Yes, next matter.
Settlement 24. Ajay Rajeshwari, TS petitioner, Govind Rai, Commerce.
For the respondent hearing, Your Lordship.
Yes.
Your Lordship, I want to bring to your kind attention that the copy served by the petitioner herein is the RPFC copy, Your Lordship. It's not the WP copy that was served to us, Your Lordship. The RPFC copy was further then amended for this the RPFC copy was the earlier petition filed, and then subsequently this writ petition was filed. So they
Now,
have
how
to
does it
service.
matter? Page numbers, if there is any difficulty, then we can look into that. For that, no adjournment.
No, Your Lordship. Few pages are also missing. Few annexes are also missing, Your Lordship. They're not incomplete.
No, serve it tomorrow. We will take tomorrow. So let her also have the satisfaction that she had today's adjournment.
Your Lordship, week's time may be given, Your Lordship.
No,
A humble request.
No. Day after tomorrow, at the request of learned counsel, counsel for the petitioner shall serve the copy of the writ petition on the counsel for the respondent. Next matter.
Number 25. Bharat Kumar Shetty, K for petitioner. Telecast Gogi, a respondent.
Appearing on behalf of respondent, Your Lordship. There is one fresh matter which they have annexed, attached, connected to this case, Your Lordship, wherein the copies are not served to us, Your Lordship. And they are submitting in the court hall that there's a wrong address mentioned, Your Lordship. And then
Give server. This also tomorrow.
yes, Your Lordship. Meanwhile, there's one more submission, Your Lordship. Here in WP 19042, interim order was passed on 22/9/2023. Thereafter, it was extended till 15/12/2023. On last date, when the matter was listed on 25/4/2024, there was a hearing on the application for not.
We'll see all that. We'll
Your
see all
Lordship,
that
interim
tomorrow.
order
Tomorrow,
has to be
no further
extended.
adjournment. Why everybody want day after tomorrow? Day after tomorrow, no further adjournments will be granted.
Copies to be.
Copy to be served on the counsel for the respondent.
Grateful.
Yes.
Number 26. K Srihari.
In this, have you informed the other side? Tomorrow we will take it. Tomorrow, poses tomorrow. In the morning during the mentioning time, without even informing to the other side, a mention is made before this court. Later, it was brought to the notice of this court by the learned counsel for the petitioner. Poses matter tomorrow. Sometimes what happens is No. That is sometimes the stenographers, when the list is going fast, without petition respondent, they'll write something or the other. Yes. Tomorrow, post tomorrow.
Please.
Yes.
Till number 27. 27 urgent. 28. Till number 28.
27 also he was making a mention in the morning. Which one? No Passover. At the request of land council, the petitioner posed this matter on 7th of August.
Till number 29.
My lord, appeal for the petitioner in 622, my lord. My lord would recollect that this is the matter. The court had already heard the matter and fixed the deadline for fixing completely cross-examination. I came before the court all the way from Bombay on 16 occasions, my lord. Court had directed to complete the cross-examination in the middle of this, when the cross had started. Till date, not even 50% cross is completed. My lord, what happens? They do the cross-examination only for 30-40 minutes. And the matter is not completed. And every time we are saying that we are willing to wait from morning to evening, please take 2 or 3 days, complete the hearing. That is one part. Now in between, my lord, what happens? The learned judge has passed an order.
Who has filed this petition?
My lord, me. I am the petition.
Huh?
There are 2 petitions, my lord.
No, here.
Both of us have filed, my lord.
What both of you want now?
I am challenging maintenance is on the higher side. My learned friend is challenging it is on the lower side.
In this matter, this matter was directed to the cross terms of the 8 and continuous rate of the first rate. But cross examination never happened due to the interference of the advocate hearing of the respondent. Means the respondent hearing.
Why can't the court take care of it?
There is material to this.
Also, thereafter, when the court entered in the order, there were 2 memos which were being filed by the advocate. Petitioner or respondent hearing. And the court just referred to the principal judge.
What is the memo for it?
Memo that means allegation of bias was made as 2 memos against the presiding officer, not after interference and recording was made. Next day itself they made a memo.
So wherever there is a memo given by the party, the court will recuse from hearing.
Court has passed on principal family judge.
This is what is the whole difficulty. No, parties are taking advantage of it. Now what they feel is, you give a memo, you file a memo, the judicial officer, officer will be will say, I'll not hear it. That should not.
That is not the case also, my lord.
This is Bangalore court.
Secondary. And so that was solved for 2 months. 2 months, no proceedings have gone, and it was. And anything making for 70,000 rupees was awarded by the family. They are also approached this honorable court. We have also approached this.
According to you, it is less.
It was less, and now also it is less, because this annual income tax income 8 crores, 8,000, 8 crores, 8 lakhs.
How much you claim? How much you claim?
3 lakhs 50,000. This is right. And the honorable second additional family court was please provide only 90,000, considering the salary of 8 lakhs. He has no other annual income, excluding the salary. But still, his salary is 8 lakhs, and his annual income is 8 crore 8 lakhs, which is improbable as per the page number 500, it is very clear by the family court judge that his annual income is for the year 2023, 24.
Use the file.
500, volume 2. Volume 2. Page number 500, it's the last page. Last page.
No, first let's see the order.
500. 500. Page number 500. 499, number 15, last line. Similarly, I see return, last three lines. Similarly, I see return pertaining to the 3 years, 2021, 22, 23, 26.
No, when earlier 70,000 is granted, it is again remanded. Now how much is granted?
Now 90,000 is granted. And now this, considering this space because 8 lakh, which is our, his salary would be crossing 50, 60 lakh rupees as per the income tax. But I got this onward for the page number 451 and 451. 450 and 451.
Your annual income is 33 lakhs.
And right now, but it was not there from 2016. Application was filed in 2017. It was prolonged for 7 years in Mumbai, and thereafter it was transferred on an order of the Supreme Court by a transfer petition. And it was
His income per year is 4 crores.
his income is 8 crores, 8 lakh rupees.
Where do you get that?
At page number
Latest is 8 crores, 8 lakhs, 15,550.
500. And he produces a salary slip of 8 lakhs 80,000. Only one salary slip of 8 lakhs 80,000.
Yes, sir.
I write this on the court to read the affidavit.
Page number.
Assets under 329, page number, volume. Second, starting page. At page number 324.
Is that?
Volume 2 is 320. Starting page, 320. 324 are here.
Yes.
Yep, he declares monthly salary, yep, 3 member, not a, yep, he declares salary income. Next. At serial number 8 member, at 325, yes. Covered in income tax returns, he states that income from the other sources such as rent, interest such as is covered in the income tax returns. Assets, movable and immovable.
No, where are you reading?
At page number 325. 325, starting at serial number 8, which comes at
Income from other sources.
it includes the income tax. And G minor is the assets movable and immovable. He states that he doesn't hold any joint family property at serial number 2. He states that he has no ancestral property at serial number 3. He has no other joint family accounts, investment, FD, mutual funds, stocks, and debentures at serial number 4. Thereafter, at serial number 8 minor, no properties alienated. He has not even alienated any property in that case. At I minor, he is not doing any self-employed business also, not applicable. So he states that there is no source of income excluding his income from the salary. He works in Morgan Stanley India Company as a director.
Then income tax returns would be disclosing what is his income. Where are the income tax returns?
At page number 451. Here, this is only one sheet of acknowledgement of income tax. At 451.
This is how it should be filed as for the judgment of Rakesh versus Neha.
Yes. This acknowledgement is filed. B was will be there, which is not filed by the at income, he has stated at column number 2.
No, you're with your salary of 8 lakhs. Per annum, how much it would be?
My lord, I am getting incentives also and the bonuses for the performance. Therefore, my entire year's
No,
income.
will the bonus would be 100 times than your salary?
Because I'm working in the fintech industry, my lord. Wherever the performance comes, I'm heading the company, my lord. So therefore, I get lot of bonuses, much more than the salary, which is.
Then in that case, consistently, it started from 3 crores and or 4 crores.
Yes.
So every year by year, it is increasing. Now it has come to 8 crores.
Yes, my lord.
So why she is entitled only for 90,000?
Let me point out, my lord, because their entire contention is based upon one single point, it is my income. Let me point out that she stayed with me only for 6 months, that too in the year 2014. I was the person who approached the family court first because I realized I can't stay with this lady. And I applied for the divorce. After that, as a counter blast, all these proceedings are initiated. That is one, my lord. Am I really? And she's a qualified, educated woman. She's been otherwise earning about 33 lakhs in a year from her own income. She has worked for Google. She herself is very qualified. Question is what, my lord? We separated admittedly in the year 2015. After 9 years, because of my hard work, I grown in my own industry, not because of any contribution from her side. Am I really supposed to pay out of my own legally generated income? Whatever is placed on record, my lord, everything is fully like as per the Neha and Rajni judgment as well as the order given by this court in one of the connected proceedings. And there nothing is hidden. Question would be what, my lord? According to me, there are two submissions. She stayed only for 6 months. We got married in 2014. In 2015, we separated. And secondly, my lord, looking at
But she is your wife.
yeah, I applied for divorce, my lord. Even now also, my lord.
Till it is granted.
Yes, my lord. But the question is what has been her contribution? Rajnish and Neha also talks about the duration of stay together. For a short duration, I can't be burdened for the entire life.
What did the Supreme Court say?
Yes.
That you shouldn't be granted maintenance.
No, my lord, it doesn't say. My lord, what I'm trying to point out, she is a capable, independent, educated woman. She can sustain.
It also says that whatever is the maintenance that is granted, that should be befitting the lifestyle of the husband.
Yes, I'm making this money now, not at the time when I got separated, my lord, in 2015. Question is what has been her
So
contribution?
let us, even if we take your money as on that day, your
That was
income
very
tax
limited.
returns, it is 4 crores.
No, in that year it was not 4 crores.
How
madam.
much it is?
I need to check that.
Accordingly, we'll calculate from the date of petition, how it is. Presently, how it is, we will make a distinction.
Let me take the court through the pleadings. What has been their contention and what is my contention about the cruelty committed
No,
to me?
not all that. Now we will go to, please come to, when was this MC filed?
We filed in 2017 from our side. That was the first.
When was the IA for maintenance is
It
filed?
was filed in 2019.
So 2019, what are your income tax returns?
My lord, I need to cross verify. Because that I did not think this question would be. My lord, but as per we have got the details from 2021, 2022, my lord. When it was 5 crores, 88 lakhs. My submission
5 crores?
88 lakhs in 2021 and 2022. That is the material placed on record before the trial court. My submission
So
would.
let us go with only 5 crores, 88 lakhs, not 8.5 crores.
Yes, my lord. The thing is that, my lord, let me point out from the pleadings, what has been her contribution in my life, in my growth. I was nothing
Did
when I got
anybody,
married.
no, did any of the judgments say that if a wife had contributed for the growth of the husband, then only she is entitled?
Not
for
like that, my
maintenance?
lord, because we separated in 2015. At that time, I was working merely as an advisor in the company. It is afterwards when I started working extremely hard, when I started staying alone. I grown in the company, my lord. At that time, I was no better than an advisor in the company, my lord.
Look at it from when a petition is filed, what is your financial capacity? No, even court has gone to the extent of saying that 2021, when the petition is filed, what is your financial capacity? That we will take into consideration. And admittedly, according to it is 5.88 lakhs, 5 crores, 88 lakhs.
Yes, ma'am.
So definitely the amount that is granted by the court is on the lower side.
But she is herself working, my lord. She is making money. She is educated. She was working
33
prior
lakhs.
to marriage.
No, even if that 5 crores is that is not considered, still your income is 88 lakhs is there above that. Our income is only 33 lakhs.
Yes, my lord, the question should be, am I really supposed to maintain in this kind of scenario when I was not making that kind of money when we separated in 2015? Thereafter,
She is not filed in 2015.
Well, I filed in 2017.
Then only she has also filed an IA.
Yeah, thereafter she filed. She did not initiate. As a counter blast, these proceedings have been initiated.
You can't look at it that you know that while you're making submissions, what is the scope of this petition? What all you may be saying may be right, that will consider the court will consider in that petition. Now, when your income is this much, you are entitled, she's entitled for the maintenance.
Yeah, my lord, we are paying that. Earlier it was granted 70,000, my lord. My request has been that like let it be sent back like.
No, not sending back. How many times? No, the material is before the court. You are not denying. There should be an end to this. Every time everybody is coming to the court and sending it back.
Let it be reduced to 70,000, my lord, because she herself is earning. She is capable. She was working prior to marriage. After marriage also.
Court is contemplating to increase it. Where is the question of reducing it?
My lord, look at the conduct of the party. Let me point out from their application what is their contention in their application. Pleadings, my lord, there is no material. Literally everything in the air. When I file a proceedings, thereafter, in order to harass me, she files all these cases, including 498A. Everywhere there are different contentions. I was very much willing to complete the trial. It has never been completed. Even the proceeding, one of the proceedings has started in the magistrate court. There also, she came only for one single date, hardly 5 days back, and lot of scene was created. I'm facing that difficulty. I'm supposed to.
All this is court can't consider. Court can't consider all that. Yes.
No, let me point out the pleading, my lord. There is nothing on record to indicate that she does deserve this kind to be increased, my lord.
1 minute. What is that? By looking at what government, assuming we'll take everything what you say on its face value.
Yes.
That there are disputes. She has been harassing you. You are made to go around the courts and so many things you're pleading. No, those are not the things to consider while determining this application for maintenance. And even if whatever the court is, no, it is your income is somewhere around 8.5 crores. And the court has granted 70,000. For that, you file a petition to reduce it.
But the prima facie case has to be made out from the reading of the
It is not injunction that prima facie case.
Because there has
Prima facie
to be
case,
some
you are
cruelty,
married.
some sort of cruelty.
No. In this maintenance petition, prima facie cases, you are married.
Yes, my lord. She is also earning. I am also earning, my lord.
She's also earning. You are earning more. Is her balance of convenience.
My lord, the thing is that, my lord, she was staying with her parents earlier than marriage, but for 6 months staying with me.
Mr. Counsel, because why the court has no problem to hear you, but ultimately what your arguments you are addressing, I can understand. Now, even if I hear you for 1 hour also, what would be the conclusion of the court would be the same. That's what please understand. Now, as far as this maintenance aspect is concerned, what is your capacity, what is her capacity, and what is the amount? That's only we can consider.
But short
Nothing else.
duration. There has not been.
There are
Even
so many cases
Rajaji sir,
even for
Neha
her.
says.
She is your wife.
But my lord, but the very short duration, that is also one of the important criteria as per Rajni's and Neha's judgment, my lord.
Please point out.
Yes,
That's
ma'am.
what I'm asking you.
Yes, ma'am. I point out.
Yes, page number. Which para?
Yes. But consider para number 74.
Yes, 74.
I'm trying to highlight para 74, 77, 78 and 86, my lord. Para 74 says, in contemporary society where.
It is with regard to permanent alimony to be paid.
Yes, my lord. When
Permanent alimony.
Except, what I'm submitting, if it is the criteria for the permanent alimony, it could be the criteria for the temporary arrangement to be done, my lord.
That I'll record.
No, because if the permanent alimony, she is not able to make out a case of harassment and we stayed for a very short time. In that case, my lord, can she be said to be entitled for the much higher amount of money?
When the court gives a direction to the court below to dispose of the matter, you will file the memos.
My lord,
You are
let me
making
point out, let me touch upon
allegations.
that point. I'll produce that copy of the memo. What happened, my lord? We are coming on 17 dates of hearing for the purpose of facing the cross-examination. Look at their conduct, my lord. They do not do effective cross-examination. Not only that, my lord, when they are supposed to.
But you have alleged malafide to the.
Not malafide, completely a false statement, my lord. Why does he not produce the copy of the memo? My submission was that every time they come, they do the cross-examination only for 30-40 minutes and they go away. And the court is accommodating. That is my difficulty. And my lord,
if the court is accommodating, for that, how can you allege malafide?
Not, I did not allege malafide.
Saying that the court is biased.
No, my lord, I did not say that there is a.
What is that memo of yours? What did you file?
My lord, then I'll tender it, my lord. It's not part of this proceeding, my lord.
What did he say?
He says that there is a bias. Means like that.
No.
I will produce 2 memos which are being filed by them itself. Because one was signed by the junior and one was means 2 were filed. In the last occasion, this honorable court, the memos were being put up to your.
Once this MC itself is disposed of, then all those things.
I'm
would
very much
arise.
keen, my lord. I'm more than
Had you
happy to
been
do that.
keen, had you been keen, you would have not said all that.
No, my lord, my difficulty is that despite of this court passing the order, this court had initially said the deadline of 8 dates of cross-examination. They again came back. Another 3 dates of cross-examination was extended.
Then the court did not address a letter
What,
for
Your Honor,
extension
my
of
lord,
time.
let me point out.
Court has granted a time of 45 minutes for cross-examination. Each and every question was not even answered. He always interfered. That was recorded in the third cross-examination itself.
Well, let me produce a copy of the evidence, my lord.
3 questions or 4 questions.
We'll pass final orders in this, get those also so that to understand how the matters are pursued. Pose this matter on day after tomorrow, not possible. Pose this matter on 31st.
My lord, just one request, my lord.
File your execution, don't wait for the court. Then if he is not obeying the court order, then you please
My lord, I
file
already
a
paid 15 lakhs.
file a petition before the, 1 minute, file a petition before the court till he makes, that is his MC, no? File a petition before the court till he pays the maintenance. Then I passed other order, some order in the other day, saying that let the court not proceed because he is not paying the maintenance.
It is also pending, my lord, for that honorable court. All the matters were being referred to the principal court on 13/6.
Can you oppose this matter on 31st? Yes, next.
My lord, just one request. Can it be on the 1st of August? Because I'll be.
1st of August.
Yes, thank you. Allow me to amend the petition. I'll place all the pursuits on record as well as the evidence to indicate.
There is in many of the means compromise. It would be very great because of the advocates, the matter has been prolonged for very long years. I seek this sample.
No. If you prolong it, he'll have that, he'll be paying 3.5.
Paying the money from out of my
No,
pocket. I'm not
3.5
interested.
you will pay, that's what she's seeking for.
My lord, that's their intention. What they do, my lord. They are in Bombay city where another matter is going on. She made the allegation against the judge. I'll produce that also on record.
No, is there intention for your client to settle this matter?
My lord, how much they are demanding? 13 crores for staying 6 months with me. 13 crores.
Yes.
That is her demand in black and white. Now, last week they sent a message for 8 crores, my lord. 8 crores. Last week they sent another message through another person in Bombay city. Common person bid, 8 crores.
So how much you are ready?
My lord, I had offered, when the mediation had taken place in the Supreme Court, I had offered 2.5 crores because we stayed for a very short duration. She made allegations against my father and my brother who's working in USA. He came only for 2 weeks to attend the marriage. Against him also the allegations are labeled. Very educated advisor to World Economic Forum, my lord. He's a researcher. Against him also allegations. It's such a vindictive attitude, my lord.
It won't happen. Yes. Oh. First of, huh?
But small, it will compromise because lots of litigation will end up.
My lord, last week they sent a message of 8 crores.
No, where is this 2.5 lakhs, 2.5 crores he is ready and 16 you are asking. Okay, where will you meet in between?
But this is the what 13 crores. I am not in before other than before this honorable court itself. He has offered, but that is also not accepted by the client in the next appearance itself. Then his
Did I create any hurdle in her life? My lord, she was working when she was
Post
married.
on 1st August, call the next matter.
Yes.
Number 30
Tell you.
Let the mediation, they do. These kind of things is just waste of time. Nothing will happen. 31.
Number 31.
Only, all these conciliations as far as the children are concerned, not for the spouses. Yes.
One, Shilpa Prasad for petitioner, Nityanand B. Nayak.
Which matter? 30. As per the directions of this court, on 28th July, the petitioner is husband. Petition is the respondent husband had appeared before the NIMHANS, and a report is placed before this court dated 28th July 2024, wherein it is, wherein the doctors have reported that the cross-sectional assessment and mental status examination is not suggestive of any psychotic disorder. However, the past history of his psychological status needs to be obtained through a detailed interview of a close family member. He had preferred to come along with his brother for review and requested for appointment on 27 July 2024. And accordingly has been given appointment to come on 27 July 2024 at 9 AM. Post this matter on 31st, by the time the NIMHANS shall place a report before this court, and the Registrar Judicial is directed to communicate the same to NIMHANS. Yes.
Cell number 32. Balakrishna K for petitioner, T.R. Rajeshwari for respondent.
You are for the? Where is the counsel for the petitioner? Any interim order in this? No interim order. Post this matter and on 12th of August, no representation for the petitioner. Counsel for the respondent is present.
Cell
So
number
give the,
32.
call the judgment matter.
Cell number 1.
Take that.
Kindly see the paragraph.
Partition Act, section 3. That also you take one. Yes.
Paragraph 1 may kindly see. It is also pertaining to the partition suit, my lord, where it was went up to the final decree proceedings, my lord, in which, my lord, there also the auction was taken.
Whether that was the issue fell for consideration,
Yes, please.
that whether the party for the partition, for that auction, whether that will apply or not.
Yes, yes, it is also considered by this court, my lord. May kindly see, my lord, lord, page number 4, para 8, my lord. The tabular form, my lord, which was called out by this court while dictating the judgment. Later on, my lord, may kindly see, my lord, para 11, my lord. 11. May also notice, my lord, section 21, rule 84 was also drawn the.
Here the important aspect is.
Yes, please, my lord. The 11.
Who has purchased the property is the question.
What?
Who has purchased the property is the question. It is not the joint family members.
It is, my lord, may kindly see.
Respondent 1678 were purchased.
Not your case. In the judgment he is referring to. Some new judgment here. Give him a copy of it.
Please, please, I will give.
This is outsiders. This particular sale is by the, because if you come to para 4, that
Para 4
will
after
be
the
clear.
directed the property be sold in auction, petitioner filed an application under order 223 of partition act, requesting court to permit him to participate in the auction for purchasing
That was
the
dismissed.
share of the.
That was dismissed.
When?
That was dismissed. It was not questioned. So now he is no more in the purchaser. Purchasers are outsiders.
That application was dismissed.
Uh.
That also application was
So,
dismissed.
what I want to know is, please point out from the judgment, who has purchased this purchase is a open auction, outsiders.
Please. In that scenario also, my lord, court taken into consideration, my lord, though my lord is not a party, the co-sharer of the property, that was also taken into consideration.
Let us see.
That was what the dismissal order was challenged in this writ petition, my lord. May kindly see, my lord, after the para 11, may kindly see me. The order 21 rule 84 was also taken into consideration. It may also notice here that the balance of bid amount in view of the order 21 rule 84 of CPC is required to be deposited within 15 days from the date of action in case of
19,
in this
19,
case,
para 19 and para 20.
after the referring this the paragraph, the Supreme Court judgment, my lord, para 16,
This is,
para 16.
I have seen this judgment, this.
No, it
judgment
is
not-
squarely applicable to this case, my lord, Hannah. Please.
No,
Nee.
judge, please come to the judge's finding. That is what is the finding.
Please.
Para number 20.
20. Please.
This argument in my view is untenable.
Para
Whenever a
19,
property is
para
ordered-
19 may also seen.
Ah.
Learned counsel for the respondents contend that the provisions of order 21 rule 84 cannot be applied on an auction conducted under the provisions of the Partition Act. And it is only in respect of sale in execution of the execution that the provision of 21 rule 84 goes CPC could apply. Number para 20. This argument in my view is untenable. Whenever a property is ordered to be sold by way of auction by a court, necessarily the court would have to follow the principle laid down under the order 41 of the CPC. It does not matter whether the sale is conducted under the Partition Act or under any other enactment, and so long as the action is by the court, the procedure prescribed under order 21 rule, order 21 of the CPC would have to be followed, irrespective of partition suit or the Partition Act, whatever it may be. Section the para 21 may kindly see. The gross and incurable illegality of not depositing the action price within the statutory period prescribed timelines were noticed when the records were purged and a copy of the memo filed by the action purchaser was discovered by this court. Though the argument advanced by the petitioner was on the aforesaid mentioned ground that the reserve price as mentioned mandate under the Section 2 of the Partition Act had not been indicated, in my view, since the memo indicated the dates on which the deposits were made pursuant to the action had rendered the very sale non-est. The impugned order is required to be set aside, and it is thus declared that the very action sale is rendered void by the non-deposit of the action price within time frame and provided under the Order 21 Rule 84 and 85 of the CPC.
Yes.
This is what this court felt that irrespective of whether it Partition Act or the CPC, CPC would
It
apply.
has to be followed. Yes,
Has to be followed.
please come. Megha?
Mega.
Huh? Mhm. Ah, okay. Come. Please come. No, where is that last that he has given, no? Some, not citations, that's in office, where is it? Give that also. Today he has passed on, yes. Where is my notes? Also here? Huh. Partition. So, CPC. Or 21. What is Rule 78 or 21 Rule 78? What does it mean? No, they're all, no, I'm just asking what is it? Hmm. So, no, the argument of the senior counsel in the morning is, like, if any sale is done without following any of the procedure, or it is a nullity, it need not be questioned, so according to the submission of the senior, no sale, the sale certificate, not sale, that nobody needs to question it. Court will come to its conclusion on its own. No, without even questioning any of it, still the court has to declare that such a sale is void in view of so and so, so and so. Yes, that also will do. 84. So you shouldn't read 78 along with this. 78 has to be read differently. Yes. 80? 80? Hmm. Hmm. (84)(2) says? No, 84(2). No, in this case, the purchaser is also a decree holder. Purchaser is also a decree holder. Now, it has to be, for example, if it is 1 lakh rupees, 80,000 will go, 25,000, 20,000 will come to you, 80,000 will go to them. So why not 84(2) applies to you? Your senior counsel has not submitted about 84(2). He has submitted about 84. 84(2) is an exception to 84.
Some other person who are not interested in the property, they have received their money and they have voluntarily, they have filed a memo.
No. You're saying that 84(1) is a condition whereby you have to immediately do so and so as per the notification. Now, in this case, where the decree holder is a purchaser and is entitled to set off the purchase money under Rule 72, the court may dispense with requirement of this rule. Please read 72. Yes, please come. Yes, please come. The present writ petition is filed. Agreed by the order passed in IA number 1 of 16. Dated 10th October 2017 in EX number 2371 of 2012 arising out of not arising, in 2371 of 2012. The petitioner before this court is the defendant in the suit. The suit is filed for partition. OS number 5590 of 1996 was filed seeking partition in respect of plaint A, B, and C scheduled properties that came, and the plaintiff claimed 1/10 share. The property, as far as the C schedule is concerned, is dismissed. And as far as the 110, as far as A and B schedules are concerned, the suit was decreed. Thereafter, against that, RFA number 649 of 2012 is preferred. So it is RFA 649 or?
RFA number?
RFA number 2411 of 2006 was filed that came to be allowed on 24th of July 2008 in the light of the compromise memo filed by the parties. As per the compromise memo, as per clause number 8 of the compromise memo, both the appellants and respondents have mutually agreed that the B schedule property cannot be divided equally among themselves and cannot be put into separate possession, and thereby the appellants and the respondents have agreed to sell the B schedule property in public auction in FTP number 88 of 2006 pending before the court within 10/4/2008 by extending full cooperation between themselves. Further, clause number 9 reads that the appellants and the respondents have mutually agreed to divide the sale proceeds among themselves according to the share declared in the preliminary decree after deducting all the legal expenses for the sale of the B schedule property in public auction. The appellants and respondents are entitled to bid in the auction without initial deposit. Thereafter, not thereafter, the suit B schedule property is property number 17, 5th Cross, New Palasi Palyam, Extension, Bangalore, consisting of a 2 floors building measuring 2,400 SFT. As per the On 13/5/2011, is the date of auction. And as per the same, the highest bidder has to deposit 25% of the bid amount. On 14/6/2011, 15 days time expired on the said date. On 8/6/2011, the highest bidder filed a memo to deposit the amount. On 11/7/2011, amount was deposited as per the, amount was deposited. 11/7, amount was, as per the memo, it was to be 11/7/2011. But it was deposited according to the petitioners on 21/7/2011. Hence, they have come up with these two applications before the court. On on 25. On 16/11/2016, they have sought for a relief that to permit the petitioner herein to retain his share in the property or direct the auction purchaser to withdraw the money deposited by him without claiming the share of the respondent number 3 in the interest of justice and equity. Then the other relief that is sought is that the court may be pleased to stay the proceedings in the execution petition pending disposal of the case in FDP number 88 of 2006. Both these applications came to be dismissed by the court by virtue of this orders impugned. With regard to the first prayer that is sought, the court had observed that the court has passed an order on 11/11/2011 directing issuance of the sale certificate to the purchasers who are the sisters. The sale certificate was issued and the same was registered on 15/6/2012 in favor of petitioners, in favor of the sisters. The petitioner before this court, who is the brother, who is the third respondent, has participated in the proceedings before the High Court in RFA number 2411 of 2006. And he has not challenged the public auction as well as a sale certificate. The third respondent is stopped from seeking any relief to retain his share in B scheduled property by way of application in the application. In the FDP, memo of calculation was said to have been filed by the petitioner on 2/4/2014. And the court has ordered for the payment by the order dated 17/9/2014 that the amount of rupees rupees and that the amount is held in the court until the position of the first floor of the property has been delivered to the sisters by the brother, that is the petitioner hearing. The third respondent, brother, that is the petitioner herein, the court has observed that the court had extracted the court has recorded about RFA number 649 of 2012, which was preferred. Again, is the order dated 11/11/2011. That is a sales certificate that is issued in favor of the sisters. The said appeal was dismissed as infructuous. The court has also observed that it is unclear from the records as well as in the affidavit to the IA if the order dated 17/9/2014 has been complied or not. When there is already an order as to the share of third respondent to be held in the court, and again passing an order on the very same claim of third respondent cannot rise. The share of the third respondent is to be handed over only after possession is delivered to the petitioners 2 to 4 pertaining to the first floor of the property. When that is the case, the prayer that is sought in the IAs cannot be permitted. And another prayer that is to retain the share and to permit only the withdrawal of the amount deposited in view of the earlier, in view of the order which is already passed by the court, the point for consideration, it cannot be considered. Accordingly, both the applications are dismissed. Aggrieved thereby, the present writ petition is filed. This writ petition is filed in the year 2017. Then in the year 2018, IA number 1 of 20 is filed before this court. 1 of 18 is filed before this court. Where is this IA number 18? This is all. Okay, after that. IA number? IA number 18 or 17? IA number 1 of 18 is filed under Order 6, Rule 17 of the CPC, read with Article 226 of the Constitution to raise additional facts and grounds wherein grounds are raised that the law, as per the provision mandates that the amount has to be deposited after completion of the auction. In this case, it has not been deposited. As such, a serious default has been committed by the auction purchasers. On the date of auction, 25% of the bid amount has to be deposited and balance amount shall be paid within 15 days thereafter. And in the event there is a default to make payment within that date, the auction would stand abated on its own, and any subsequent deposit made beyond 15 days is void, and it is a nullity in the eye of law. Further, it is the other ground is laid that it is under the Indian Partition Act, no separate procedure is contemplated so far as action of the property is concerned. Therefore, any provision available in Partition Act is only an enabling provision, and procedural aspects are concerned. The procedure contemplated in the CPC is required to be followed. Under Order 21, Rules 84, 85, 86, and 90 of the CPC, a procedure is contemplated so far as conducting the auction and making deposits of the bid amount is concerned. And according to that, the highest bidder has to deposit 25% of the bid amount, and balance 75% shall be deposited on or before 15 days from the date of the auction, as contemplated, as it was not done. The auction procedure is vitiated. And in the grounds, they have relied on the judgment of the Honorable Apex Court in Balram versus Elam Singh, reported in 1996, 5 SCC 705. And also Ram Karan Gupta versus JS Exim Limited and others, reported in 2012, 13 SCC 568. So by the petitioner wants to amend his pleadings by virtue of this application. Then a senior counsel appearing for the petition, appearing for the petitioner had argued in the similar lines and submitted that as the amount is paid beyond the stipulated time, the entire sale is vitiated, and they are not entitled, and entire sale is vitiated. Now the only procedure that is available is to set aside the sale and to conduct a fresh auction. It is submitted that as far as the sale pertaining to his client is concerned, the third respondent, who is the petitioner herein, is concerned, and his prayer needs to be allowed. And further, the amount that is deposited can be given back. He submits that the section 2 or 3 of the Partition Act is only an enabling provision, and the procedure that is contemplated in the CPC has to be followed, and there cannot be any distinction between an auction in respect of a partition suit and an auction in respect of in a partition suit and in a general any other auction. He had drawn the attention of this court to the judgment of the Apex Court in Annapurna versus Mallikarjun and another, reported in 2014, 6 SCC 397, wherein the Apex Court has observed that although Order 21 Rule 89 CPC does not prescribe any period either for making the application or the required deposit. Article 127 of the Limitation Act prescribes. No, not, that is not the bad. That in Ramkaran Gupta, after considering the Constitution bench judgment, the deposit of the requisite amount in the court as a condition precedent or a sine qua non to application for setting aside the execution of sale, and such an amount must be deposited within the prescribed time for making the application, otherwise the application must be dismissed. Then Ramkaran Gupta, I think earlier also it is in the other paragraph. Ramkaran Gupta, JS Exim Limited, 2012 13 SCC 563, para number 22. Then Rosali versus Tyco Bank and others, 2007, SC 998. Next, Patel, Kantilal, Parshottam Das, and others versus Jitendra Kumar, Nazibai Mistri, 2017 SAR Civil 618. He relied on this judgment order that the liberty to amend the pleadings, which is given, is in the nature of allowing the appellant to come out with altogether a new case, not even pleaded or argued before the High Court. Why you are relying on this judgment, 2017 SAR Civil 618?
I relate, because with regard to limitation. Maybe 617, 2017 SC, 478, Your Lordship.
No, they have relied on. That is there in the compilation.
Right, sorry.
Yes. In your along with the writ petition, you have filed the judgments. So for what purpose you have relied on 2017 SAR Civil 618? Patel, Kantilal, Purushottam Das.
In fact, I relied on the, because the limitation aspect.
Yes, the basic one.
That is, he relied on that regarding limitation.
All these citations. He has relied on Manilal, Manohar Lal Shah and others. The Sardar Saeed Ahmed and another reported in 1955, 1 SCR 108. He had relied on para 11, extract para 11. Next, Rao Mehmet Ahmad Khan versus Ranveer Singh and others. Para number 12. Next, Balram Soni versus Balram, son of Basaram versus Elam Singh and others. I've marked at para number 16. Two thousand 13 that Ramkaran Gupta, I said, no, JS Exim Limited. That is para number 14 and 19. 14, 19, 22, 23. Basing on these judgments, then a senior counsel submits that the sale that has been conducted and all the subsequent proceedings are vitiated, and the entire sale process has to be set aside. The auction, and he has also relied on the judgment in civil revision petition number 779 of 2023 in case of Sri Yuvaraja and Vardhamma and others. Relying on the said judgment, learned counsel submits that the learned judge has clearly observed that whether it is a sale under the other proceedings or under in a suit for partition, it will not make any distinctions, and the court have to follow the principles laid down under Order 21 of CPC, 22 Order 21 of CPC. When once the illegality of not depositing the auction price within the statutorily prescribed timeline were noticed and the records were perused, and basing on that, the court has come to the conclusion that the very auction sale is rendered void by the non-deposit of the auction price within the time frame provided under Order 21, Rule 84 and 85 of the CPC. One minute. And he had also relied on Gas Point Petroleum India Limited versus Rajendra Maruti and others, reported in 2023 6 SCC 391. Relied on para number 31. Basing on these judgments, then a counsel surplus of the sale has to be set aside. Next, then a counsel appearing for the respondent had drawn the attention of this court to the order passed in the RFA, basing on a compromise memo, wherein at clause number 8 and 9 of the compromise memo, where the respondent has agreed to sell the property in a public auction. In the teeth of that compromise decree that is passed, it is not open to any of the parties to agitate on the aspect that the amount has to be returned to the auction purchases, and he should be permitted to retain his share of the property. That's the application that is filed, that is IA number 1 of 16, goes contrary to the compromise decree, and the parties do not, the parties cannot make such a submission and cannot come up. Yes, cannot, what is it? And the parties cannot come up with such a plea, and it is not permitted, it is not permissible for them to act contrary to the a compromise decree passed by the court, which is binding on all the parties. it is submitted that he had relied on section 3 of the Partition Act. It is submitted that he submits that section 3 is an exception to Order 21, Rule 82 to so and so. For the same would not apply for the auction purchase in respect of a partition suits. He had relied on a judgment of this court in WP number 12119 of 2022 in case of Rajashekar Andanuri versus and others versus A. Mohan and others, wherein the issue that fell for consideration before a coordinate bench of this court was whether the provisions of Order 21, Rule 84 of CPC are applicable to the auction conducted under Section 3 of the Partition Act 1893. Whether the petitioners have made out a case to set aside the auction on the ground that they were not afforded an opportunity to participate in the auction. Therein, the contention that was raised was the respondent failed to deposit 25% of the bid amount as on the date of the auction. As they failed to deposit that same, the auction is vitiated. In that case, they relied on a judgment of Andhra Pradesh High Court in Bharatam Satyanarayana reported in case of in arising out of CRP number 3002 of 1987, dated 29/11/1988, wherein a view was taken that in case of sale under Section 3 and 4, the sale of sharers of other shareholders in favor of shareholder applying for purchase is governed by self-contained procedure under Section 7, under Section 7, which is directory in nature, and the court is vested with discretion to extend time for depositing the amount towards sale of shares of other shareholders without reference to Order 21, Rule 84 of CPC. Even in case of K. Vivekanandan versus N. Vijay Kumar, reported in 2014 SCC Online Madras 84778, the same view was taken. Court has also considered another judgment of Delhi High Court in Krishna Kumar Mehra versus Rooplal Mehra and others, reported in 2021 SCC Online Delhi 5491, wherein the Delhi High Court has held that there is no strict application of the provisions of CPC, as the legislature was conscious of the fact that in partition suits, an auction could also involve one of the co-sharer or decree holders purchasing the suit property. Hence, the provisions of Order 21 of CPC can thus be relaxed by the court while exercising its discretion. And the learned judge had considered the scope of Section 3(2) of the Act and observed that the legislature has used the word shareholder, which otherwise means and connotes a person who has a share in a property. The sale of a joint property under Section 2 and 3 of the Act of 1893 is different from a property sold in a public auction as per the provisions of the CPC, where a condition for deposit and resale in case of default are provided. when auction is conducted among co-sharers, the requisite deposit of 25% and thereafter the balance amount to be deposited within a period of 15 days cannot be made applicable where the auction is conducted in the provisions of the Partition Act. Then the court had taken the view that Order 21, Rule 84 and 85 would apply when there is a public sale of the property. When it is sold under the provisions of the Partition Act, rules do not apply, and court can extend the time for payment or deposit in exercise of its inherent powers. And the compliance of Order 21, Rule 84 and 85 cannot be extended. And court has also observed that with the auction, the provisions of Order 21 are held to be applicable to the auction conducted and the provisions of Section 3 of the Act, and they are to be deemed as directory but not mandatory. Then council had relied on another judgment in case of H.S. Gautam versus Ramamurthy and another reported in 2021, 5 Supreme Court, cases 241, para number 34. Only these two judgments? These two judgments.
Two judgments and along with
Along with that, first,
I had a memo.
first some judgment, that is the response. We'll find it in the paper book also. Based on these, and then council further submits that the sales certificate that was issued in favor of the purchaser, that is sisters, which is in the year 2012, was never questioned by which was registered on 15/6/2012, was never questioned. And now it is not open for them to come up with such a relief, and accordingly, the writ petition is liable to be dismissed. Next, this court, having heard the learned senior counsel and the counsel for the petitioner, peruse the material on record. Before dealing with the impugned order, it is appropriate to look at the applications that are filed. The reliefs that are sought, as in the preceding paragraphs, this court has observed that the petitioner herein, who is one of the co-sharers, who is the brother, he wants the relief that he sought is permit him to retain his share in the property and direct the auction purchaser to withdraw the money deposited by him. And the other relief that is sought is to stay the further, to say the I'm just looking for the number. The other is to stay the proceedings in the execution petition pending disposal of the case in FDB number 88/2006 of 88 of 2006. Then on what basis the petitioner wanted to retain his share in the property and to direct the auction purchaser to withdraw the money deposited by him without claiming the share is that in the first 1 to 3 paragraphs, he has narrated about the events. Then when it comes to paragraph number 4, it is stated that the auction purchasers are the shareholders and interested parties in the suit schedule items, and taking advantage of the situation and misunderstandings prevailing amongst them, the decree holders did not deposit the sale consideration amount on time, and it was not allotted and delivered to the petitioner. There is an inordinate delay and no benefits could be derived to the decree holder even after the deposit of the value of the scheduled property before the court on a later stage. If the physical possession of the property is taken, they'll be put to untold hardship and would not meet the ends of justice. So in this entire affidavit, he has not stated about anything with regard to any of the chronology of events that had taken place subsequent to the order passed, judgment, a compromise decree that is passed in a RFA. And he has not even taken any plea with regard to the auction being vitiated and several other grounds. Now, by way of an amendment, a petition, that is an application sought to be an application under Order 6 Rule 17 of CPC is filed before this court, wherein he is permitted to, wherein he can plead, take all these grounds before the court. That is by way of IA number 1 of 2018. While this court is exercising a supervisory jurisdiction under Article 227 of the Constitution of India. Now, while exercising the supervisory jurisdiction, the pleadings which are supposed to be taken before the court below, and the pleadings basing on which an order is already passed and which is assiled before this court, which has to be adjudicated by this court with regard to the legality or otherwise of the said order, Vaishnav permitting the party to amend the affidavit that is filed before the court is beyond the scope of Article 227 of the Constitution of India. This court cannot entertain such an applications. Accordingly, IA number 1 of 2018 cannot be considered, and accordingly, IA number 1 of 18 is dismissed. Next, when the sale certificate was issued on 11/11/2011, and it was registered on 15/6/2012, when the petitioner, being a party in all the proceedings, he has never chosen to question the sale deed, and those proceedings have attained finality. the submission that is made before this court that it is, as there was no, that order 21 rule 84 of the CPC is not followed. As no such application is filed to set aside the sale certificate or questioning the sale, questioning the proceedings, but still this court is empowered under Article 226, 27 to go into all those issues. Even such an argument advanced by the learned senior counsel also has no legs to stand. The powers of this court under Article 227 cannot be exercised in such a manner. Secondly, he was a part of he was part of the he has also consented for a compromise decree. He was a signatory to the said compromise memo that is filed before the court, wherein all the parties have agreed to put the property, rescheduled property for auction. In that case, unless and until that compromise decree on whatsoever grounds it is questioned, it is challenged, or something else has been ordered, it is not open for the party to a compromise decree to come up before a court and file an IA which runs contrary to the judgment and decree filed by this court, passed by this court in a RFA. First, on this ground alone, these writ petitions have to be set aside. These writ petitions have to be dismissed as such a relief that is sought by the petitioner cannot be granted by the court, as it runs contrary to the judgment, a compromise decree, or in view of the memo filed by the parties in the RFA. On that ground itself, that IA of 1 of 16 needs to be dismissed. Then the other relief of staying the FD proceedings also do not stand for any scrutiny in the light of the first prayer, which cannot be entertained. Then both the parties have relied on the procedure that has to be followed under under the Partition Act, Section 2 and 3, and they have relied on two judgments of this court, conflicting judgments of this court, where in one case, which is relied on by the petitioner, the learned judge has taken a view whether it arises out of a partition suit or it is out of a normal civil proceedings, but still Order 21, Rule 84 has to be followed. Whereas the judgment that is relied on by the respondent, in that case, a learned judge of this court had taken a view that when the proceedings, when the action has taken place in a partition suit, Rule 2 and 3 of the Partition Act will apply. In that case, the strict timeline under Order 21, Rule 84 need not be followed, and the court has the power to enlarge the time. This court is not inclined to go into any of the aspects with regard to the sale that has taken place, what is the impact of it, whether it is vitiated or not, because that was never questioned before any court. That was never felt for consideration. The only relief that is sought is the stay of final degree proceedings, and the other one is with regard to that he wants to retain the property, and the amount which fetched by way of an auction has to be given back to the auction purchaser. Such application, the petitioner cannot maintain in the light of the compromise decree. In that view of the matter, the writ petition stands dismissed. Only for the judgments, look at that, F5. One is initially there was a confusion about respondent and petition. Yes, on 455. Yes. 30, all these matters will come up again tomorrow. Your Passover will take. Yes, other matters.
Till number 30.
Passover matters stay back. Other,
33, till
no,
number
we'll call the list. 33,
Enterprise,
let it come tomorrow. 34,
34,
come on tomorrow. Next, 36.
35.
36 million and top of
36.
list over the last three.
Which one?
36.
It has reached earlier also, last week on Friday or Thursday. Every day it can't be top of the list. Let it come tomorrow, 36. 36, yes.
Dismissal list.
It won't be. It will come tomorrow. 36, yes, 37
37.
tomorrow. 38
Tomorrow. Respondent.
tomorrow.
Yes, yes, ma'am.
Yes.
39, Continuous.
No, it's an interlocutory application. What is this? I have funded custody filed by the advocate. 39, who appears? Post this matter on 5th of August.
Till
Like,
number 40.
I think it appears to be, no, 39 appears, you appear in 39?
No, for 40.
No, 39. I think appears to be a custody matter. 29, Monday. 40,
44th of August, if you don't mind.
posting filed by advocate for petitioner 2023 FC matter. Who appears for the other side?
Other side is the Rajesh KS.
When do you want 4th of August?
4th of
4th of August at the request of land council for the petitioner.
Respondent.
You are for, is it petitioner?
Petitioner.
Yeah, no, I'm for the other side.
Respond. 41,
Okay, for respondent, or objection at vacation, okay, we have filed a vacation application.
vacate tomorrow.
They have to file the objection.
No, for everything, these objections, even at the first time, it is not required. Not at the second time. Yes.
42.
Respondent.
Huh?
Respondent of this matter.
In which matter?
42.
42.
42.
Fifth of August. 5th
Yeah.
of August.
Yesterday also is Sunday is not meet the
Let
child.
it Monday. Let it come on Monday, 42. Yes.
Till number 43. Everyone ready? Yes, sir.
What is the council's name? Print the name of Mr. P. Prasanna Kumar, post tomorrow. Yes, next.
Till number 44.
For the respondent. 44.
Leader.
Respondents. Waiting for the respondent.
You are ready to file? What
Supposed
affidavit?
to file the affidavit last week, my lord,
Uh,
and it was supposed to get listed on, it was supposed to get listed on Friday. Didn't get listed. We had made a mention.
We'll have it on Monday.
Can
Monday.
it be tomorrow?
No, he has to file he says he wants to file a reply to that. What is the report of Imhans?
It is not the report, my lord. Basically, they have flouted all the orders of the court granting the.
We'll hear it
visitation right.
tomorrow. We'll hear it tomorrow.
On top of the list, if possible.
No. Everybody's talk is not possible. Tomorrow. Yes, next.
45 is 46. Krishna is 46.
Received from the additional judge, family court, request to grant for extension of time. Take out this 46.
And for the petition.
How much time they request? Give that. This court by order dated 21/9/2023. No, and 31/2024 has directed the court within dispose of the matter within a period of 8 months from the date of receipt of the copy of the order. The judge has stated various reasons why the same could not be disposed of and requested further time of 4 months accordingly. Another 4 months time is granted, or finally another 4 months time is granted for disposal. Yes, 47. Why are you not complying with the office objections?
Day after tomorrow, by the time I am not getting files, madam. Yesterday also, day before yesterday also.
Why you will not get files? What is our submission?
I don't.
Tomorrow will be given.
Pose this matter day after tomorrow. By the time if the office objections are not complied with, the writ petition stands dismissed without further reference to the court.
I am not getting files. Madam. That's why I am
Why you will not? Make sure that his file is reaches a section, yes. 48.
Appearing for respondent, my lords.
Have you taken out notice from the respondent? You are for the respondent.
I'm for the respondent, my lords.
We'll hear it tomorrow for post this matter for hearing, for fresh matters.
My lords, kindly 5th of August.
Why? You are the
I am the respondent.
anyhow, we both of you are here, post this matter
How much?
on Thursday, 25th, next. Yes. Huh.
Serial number 22.
So some matter passed over, they're waiting, which is that?
Two, serial number 12 and serial number 23. Number 12 and 23. 23. Tell number 12.
Appear for the petitioner.
ಯಾವ್ದು sir?
It will come, it will come. No, it doesn't matter. Yes.
Serial number 12, my lords. Appear for the petitioner. Respondent number 1 by me, been passed over.
Passed over matter. Hmm.
On 25th, my lords. This is not convenient.
How many times this matter, morning Passover, evening Passover?
Tax pension about that. No, instead.
Oh, this is a 16 matter. It can't go beyond a point.
25th, lords. No, instead, my lord, 25th may be difficult. From morning, we have been waiting.
That's
So,
what, it is,
Any other
it's
time,
very
Lord, even
unfair.
24th, your lordship could have it, because I, again, 24th, Lord, I'll be.
24th,
Please.
yes.
Tell number 23.
Tax matters, my lord, I'm preparing for the department. That's
But
why I
what to
accepted
do,
it.
what to do?
It doesn't make much.
No,
difference.
I'm
not.
You should have at least informed him.
available.
You should have informed him
No,
at
I'm not
least.
available.
Why is he making? No, your colleague was there. If colleague was there, you could have told them,
Otherwise, I'll be in the court only, my lord.
we'll have it on 25th, 25th.
25th. 25th in the afternoon, but,
Huh?
morning, because there is a part of direction. matter to focus.
25th at 2:30.
2:30.
Yes.
Much.
Tell number 23. Passed over.
Why? It is adjourned in the morning, passed over. It can't go. I heard the matter, I remember. Huh? That's why I asked him to come tomorrow, tomorrow.
At serial number 31, my apology, the case was called, I was not present, my lord. The matter has been adjourned to 31/8 regarding the custody of the child, my lord. Interim order may kindly be extended.
Serial number
31.
31/8, interim order earlier granted is extended.
Much of.
ನಾಳೆಗೆ ಇರೋದ್ ಮಾತ್ರ ಇವತ್ತು ಬರ್ಕೊಳ್ಳಿ ನಾಳೆ ಅದೊಂದು ಬರಿಬೇಕು ಸೀರಿಯಲ್ ನಂಬರ್ 20 ಅಲ್ಲ 20 ಯಾವ ತರ ಪ್ರಸನ್ನ ಕುಮಾರ್ 43 ಸೀರಿಯಲ್ ನಂಬರ್ 43 ಇಂದ ಏನಂತ ಹೇಳ್ಬೇಕು
ಬರ್ಬಿಡಿ ಮೇಡಮ್ ಬರ್ಬಿಟ್ರೆ ನಾವು
ಏನಂತ ಬರಿಬೇಕು
ಅದೇ ಕುಮಾರ್
print the name of
registers directed to show the name of Prasanna Kumar as land council appearing for
respondent. 43.
ಇಲ್ಲಪ್ಪ ಬರ್ದಿರೋದನ್ನ ಸಹಿ ತಗೊಂಡ್ರಿ ನೋಡಿ
ಬರ್ದ್ಬಿಟ್ಟು ಇಲ್ಲಿ ಕೆಳಗಡೆ LKG ಅಂತ ಇರ್ತದೆ. ಅದು ಸೈನ್ ಆಗೈತೆ ನೋಡು ಅದು ಯಾವತ್ತು ನಾಳೆಗೆ ಅಲ್ವಾ ಅದುವೆ ಕೊಡಿ ಇಲ್ಲಿ. ನಾಳೆಗೆ ಇದುವೆ 22
23 ಇಂಟ್ರಿ ಮೋಡ್ ಎಕ್ಸ್ಟೆಂಡ್ ಆಯ್ತು ನಾಳೆಗೆ ಹಾಕೋರೆ ಗೊತ್ತಾಯ್ತು ಇಂಟ್ರಿ ಮೋಡ್ ಎಕ್ಸ್ಟೆಂಡ್ ಆಗಿಲ್ಲ ಸಬ್ಮಿಷನ್ ಮಾಡಕ್ ಬಂದವ್ರೆ ಎದ್ದು ಬಿಟ್ರು ಮೇಡಮ್ 23 ಇಂಟ್ರಿ ಮೋಡ್ ಎಕ್ಸ್ಟೆಂಡ್ ಆಗಿಲ್ಲ ಮೇಡಮ್
ನಾಳೆಗೆ ಬರುತ್ತಲ್ಲ ಹೇಳಿ ಎಂಟ್ರಿ ಮಾಡ್ರಿ ಇದ್ರೆ ನೀವು ಪಾಸ್ ಓವರ್ ಅಲ್ಲಿ ಪಾಸ್ ಓವರ್ ತಗೊಂಡು ಶಾರ್ಟ್ ಪಾಸ್ ಓವರ್ ಅಂದ್ರೆ ಇವಾಗ ಬಂದ್ರೆ
ಏನ್ ಮೇಡಮ್ ಇದು?
ಅಲ್ಲಿ ಅವ್ರಿಗೆ ಅಲ್ಲ ಅದ್ರಲ್ಲಿ ನೋಡ್ಬೇಕು. ಏನ್ ಆರ್ಡರ್ ಆಗಿದೆ 42 ಬಟ್ ಡೇಟ್ ಅಟ್ ದಿ ರಿಕ್ವೆಸ್ಟ್ ಆಫ್ ಲರ್ನ್ ಕೌನ್ಸಿಲ್ ಫಾರ್ ದಿ ರೆಸ್ಪಾಂಡೆಂಟ್ 29/7 ನಾಳೆ ಇರೋದ್ ಮಾತ್ರ ನೀನ್ ಬರ್ಬಿಡು
ಮೇಡಮ್ ಇದೊಂದು ಡೌಟ್. ಮೇಡಮ್ ಡಿಸ್ಮಿಸಲ್ ಅಲ್ಲಿ ಬರಲ್ಲ ಅಂತ ಮೇಡಮ್ ಹೇಳೋದು. ಡಿಸ್ಮಿಸಲ್ ಹಾಕ್ಸ್ಬಾರ್ದ
ಯಾವ್ದನ್ನ
ಆ ಡಿಸ್ಮಿಸಲ್ ಅಲ್ಲಿ ಹೇಳಿದ್ನ ಡಿಸ್ಮಿಸಲ್ ಅಲ್ಲಿ ಇದೆಯಲ್ಲ ಅದು ನಾಳೆ ರಿಪೀಟ್
No, it will be given coming on the same caption. Let it be there. 23 ಲಿಸ್ಟ್ ಆನ್ ನೋಡಿ ಸೀರಿಯಲ್ ನಂಬರ್ 43, 44, 43 ಅವ್ರು ಬರೀತಾ ಇದ್ದಾರೆ. ನೀವು ಬರೀತಾ ಇದ್ದೀರಾ 43, 44 ನಾಳೆ ಆಮೇಲೆ ಇದೆಲ್ಲ
ರೆಸ್ಪಾಂಡೆಂಟ್ ಒಬ್ನೇನಾ ಮೇಡಮ್?
ಯಾಕೆಂದ್ರೆ ಅಲ್ಲಿ ಇವರು PS ಇಲ್ಲ ಹೋದ ತಕ್ಷಣ ಅಲ್ಲಿ ಫೈಲ್ಗೆ ಇದು ನೋಡ್ಬಿಟ್ಟು ರಿಪೀಟ್ ಕಳಿಸ್ತೀರಾ ಬಿಂದು? ಕಳಿಸ್ಬಿಡಿ. ಡೇಟ್ ಇದೆ ನೋಡಿ
ಮೇಡಮ್ ಇದಾಗಿದೆ.
ಅದೇ ಡೇಟ್ ಇಂದ ರಿಪೀಟ್ ಬರೀದೆ ಏನಾರು ಡೈರೆಕ್ಷನ್ಸ್ ಮಾತ್ರ ಫೈಲ್ ಕಳಿಸ್ತೀನಿ. ಯಾವ್ದು
43
ಅಲ್ಲೇ ಇದೆ ಅದ್ ಬರೀ ಟುಮಾರೋ ಆ ತರ ಎಲ್ಲ ಇರೋದೆಲ್ಲ ಅವ್ರು ಬರ್ಕೊಡ್ತಾರೆ ನಾಳೆ
ನಾಳೆ ಇಲ್ಲಪ್ಪ ಲಿಸ್ಟ್ ಅಷ್ಟೇ. ಅದ್ ಸೈನ್ ಮಾಡಿಸ್ಕೊಂಬಿಡಿ ಮೇಡಮ್. ಕಳ್ಸ್ಬಿಟ್ರೆ ನಾನು ಬ್ರಾಂಚ್ ಕಳ್ಸ್ಕೊಡ್ತೀನಿ ಅಂತ ಅದಕ್ಕೆ ಅಷ್ಟೇ. ಇದು ಎಂಟ್ರಿ ಮಾಡ್ರಿ ಯಾವ್ದ್ರ ಅಂತ ಇದ್ರೆ ನಾನು ಬೆಳಿಗ್ಗೆ ಮಾಡಿ ಕಳ್ಸ್ತೀನಿ.
ನಾಳೆ ದಿವಸ ಮಾತ್ರ ಬರ್ಬಿಡು. ನಾಳೆ ದಿವಸ ಬರ್ಬಿಟ್ಟು ಅವಳಿಗೆ ರಿಪೀಟ್ ಕೊಟ್ಬಿಡು. ಇನ್ನು ಉಳಿದಿದ್ ಮಾತ್ರ ಅವರು ಹೊರಗಾಗಿದೆ. ಹಲೋ ಬಿಂದು ಲಿಂಕ್ ಕರೀತಾ ಹೋಗ್ಬಿಡು. ಯಾರು ಅಲ್ಲಿ ಏನಿಲ್ಲ ಒಂದು 4 ಫೈಲ್ ಇದೆ ಅಷ್ಟೇ. ಅಲ್ಲಿ
ಏನಪ್ಪ ಯಾನ್ನ ನಾನೇ ರೆಡಿ ಆಗಿಲ್ಲ ಇನ್ನೂ ಇವೆ ಜನ ಕೊಡ್ಬೇಕಲ್ಲ. ಕರ್ದು ಬಿಟ್ರೆ ನಾವು ರೆಡಿ ಇರ್ಬೇಕು. ಕರೀರಿ ಕರೀರಿ. ಅವ್ರು ಯಾವ ಫೈಲ್ ಕಳ್ಸಿದ್ರಂತೆ ಸದಾನಂದ ಅವ್ರು.
ಹೇಳಿಲ್ವಾ ನೀವು?
ನಾನು ಕಮಿಷನ್ ಮಾಡೋಣ ಪಟ್ಟನ್ ವಾಪಸ್ ಬಂದೆ. 1 ವೀಕ್ ಕೇಳಿದ್ಕೆ ನಾಳೆ ಹಾಕ್ತೀನಿ ನಿಂದ್ರಲ್ಲ ಅಂತ.
ಎಕ್ಸ್ಟೆನ್ಷನ್ ಕೇಳ್ಬೇಕು ಇಮಿಡಿಯೇಟ್ ಆಗಿ. ಮೆಸೇಜ್ ಮಾಡಿದ್ದೀನಿ ನೋಡಿ ನಾನು.
Madam, 23rd ಅಲ್ಲಿ entry ಮಾಡಿ extend ಆಗಿದೆ ನೋಡಿ madam.
ಹಾ ಹೌದು ಸರ್. ಇದೇನಿದು? ಅಲ್ಲಿ ಇಲ್ಲಿ ಎಲ್ಲ ಕಡೆ ಬರ್ತಾರೆ. ಈಗ ನಾಳೆ ನಾವು ಬರೆಯೋಣ. ಇದು ಅವ್ರಿಗೆ ಕೊಡಿ. ಇದು 230 ಅಂತೆಲ್ಲ ಬರೋಬೇಕು. ಹಾ ಅವ್ರಿಗೆ ಅಷ್ಟೇ ಅಪ್ಪ. ಅಷ್ಟೇ ಒಂದು ಫೈಲ್ ಡೇಟ್ ಬರ್ಬೇಕು. ಇಲ್ಲ ಸರ್ ನಾಳೆ ಬರುತ್ತೆ ಕೇಳ್ತೀನಿ. 23ನಾ? ಆಯ್ತು. ನೀವ್ ಹಿಂಗ್ ಮಾಡೋದ್ರಿಂದ ನಮಗೆ ಕಷ್ಟ ಆಗುತ್ತೆ. ಇಲ್ಲ ಸ್ವಾಮಿ ಇರ್ತೀರಾ? ನಾಳೆನೇ ಡೇಟ್ ಕೊಡ್ತೀನಿ. ನಾಳೆ ಕಲೆಕ್ಟ್ ಮಾಡಿದ್ರೆ ಓಕೆ. ಬರ್ದಿದ್ದಾರೆ ಮೇಡಮ್ ಹತ್ರ ಸಿಗ್ನೇಚರ್ ಬರ್ಬೇಕು. ಇಲ್ಲೇ ಬರ್ದ್ರು ಅವರು ಅವ್ರು ಬರ್ದ್ರು ಇಲ್ಲೇ. ಈಗ ಬರ್ದ್ರು ಇಲ್ಲೇ ನಿಂತ್ಕೊಂಡು ಬರ್ದ್ರು. ನೋಡಿ ಇದು ಏನ್ ಬರ್ತೀರಾ ನೋಡ್ಕೊಳ್ಳಿ. ಬ್ರಾಂಚ್ ಕಳಿಸ್ಬೇಕಾ? ದಿನ ನಾಳೆ ಬರುತ್ತೆ. ಯಾರು
ಹೌದಾ ಹೇಳಿದ್ದಾರೆ ಸತ್ಯ.
ಇಲ್ಲೇ ಕುತ್ಕೋಬೇಕಂತ ಹೇಳಿದ್ದಾರೆ.
ಬಾಕಿ ಏನಾದ್ರು ಅರ್ಜೆಂಟ್ ಏನಾದ್ರು ಎಮರ್ಜೆನ್ಸಿ
ಏನೂ ಇಲ್ಲ. ನಮಗೆ ಕಾಣಿಲ್ಲ.
ಹೌದಾ ಮೇಡಮ್?
ಹೌದು ಕರೆಕ್ಟ್. 41 9 ಮಾಡಿದೆ. 38 ನಮಗೆ
ನಾಳೆಗೆ. ಹೇಳ್ತಾ ಬರ್ತೀನಿ, ಚೆಕ್ ಮಾಡ್ಕೊಳ್ಳಿ. ಇದೊಂದು ಫೈಲ್ ಬಂದಿರ್ಬೇಕು ನಾಳೆಗಿದೆ. ಸೀರಿಯಲ್ ನಂಬರ್ 3 ಚೆಕ್ ಅಂತ ಹಾಕೊಳ್ಳಿ, ಫೈಲ್ ಬಂದಿರುತ್ತೆ. ಬ್ರಾಂಚಿನ ಬೆಳಗ್ಗೆ ಬೆಳಗ್ಗೆ ಇರುತ್ತೆ. ಆಮೇಲೆ ನಿಮ್ಗೆ ವೆರಿಫೈ ಇದೆ, ಆಮೇಲೆ ಅದು ಫೈಲ್ ಬಂದಿರುತ್ತೆ. ಹೋಗಿ ಇನ್ನೂ ಇದೆ, ತಪ್ಪಾಗಬೇಕು. ಇಲ್ಲಿ ಫೀಸ್ ಮಾಡಿದಂತ ಬ್ರಾಂಚಿನ ಬಗ್ಗೆ ಸೈನ್ ಆಗಿದೆ, ಕಳಿಸ್ತೀವಿ. ಓಕೆನಾ? 44 ಈ ಬರ್ಕೊಬಿಡಿ. ಈಗ ಆಗಿಲ್ಲ, ಒಂದು ಫಿಫ್ತ್ ಡಿವಿಷನ್ 2 hours ಇಲ್ಲಾಂದ್ರೆ ಎಲ್ಲ ವಿಚಾರ. Simple